From distant lands we gather, hearts of fire all along. Oh, big Nick, cause we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. Warriors of the ancient sea, songs of glory dark and bold. In the night, our spirits free, legends born, tales unfold. Oh, big because we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. From horizons wild we roam, with thunder in our soul. Every battle brings us home to the stories ages told. Oh, big Nick, cause we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight.
All right. It is officially Verdict Watch. They are back from their extended lunch, and they are currently, to my knowledge, deliberating. I have here, just to make sure, sorry, here is Judge Boyd's page, and I will refresh it every now and then, because once they reached something, she will go live, and she's not live yet. So here we are. But I will have that on in the background. So, Verdict Watch. What are we supposed to do during Verdict Watch? Well, I thought there was a bunch who joined quite late, who wondered, okay, what's with this with the cocaine stripper and all of that. So I have here. I have there cross-examination lined up for cocaine stripper. So you yourself, who missed this when we aired this a few days ago, can decide for yourself if this is a person you would hang your hat on regarding capital murder. But first, say hello to Gigi. Hello, Gigi. Good to have you here. Hello over at Rumble. And hello over at X, of course. Yeah, streaming this on 3 platforms. Dun, dun, dun. Let me get everything sorted out as well. Dun, dun, dun. So I can actually... There, now I have the chats popped out. I heard Mr. Jingles. Let's see, Mr. Jingles. He will show up if he wants to. Hello, Gigi. Hello, Gwendolyn, Siobhan, B. Jefferson, Kelly, and all you others. And yeah, welcome here. While we wait for the jury to come back. I expect, regardless of verdict, I would expect not that long of a deliberation. But I've been wrong before. I have been wrong before. So simply do not know. Do not know. But if they have not reached a verdict by, I believe it is by 4 or 4:30 Texas time, we will have to wait until Monday, which gets us to what time is it now? Is it 2:30? Yeah, so at least a couple of hours. At least a couple of hours. And I have sent out a few invites to people, and so we might end up with a Friday evening stream of sorts while we wait. I have no idea if they will show up, because if you invite people last minute, sometimes they have a hard time making the time. But for the second time, let's listen to Cocaine Stripper Girl.
And we have the witness now.
Right, defense, you may proceed.
Good afternoon, Ms. Reyes. So let's start off with your plea deal in this case. You pled to tampering with evidence, correct?
Correct.
That's a third-degree felony?
Yes, sir.
What is it that they said you tampered with?
The car.
The car?
Yeah. She was only charged for tampering with the car. She wasn't charged with tampering with her phone or any other type of evidence. Just the car, which is, well, she left it somewhere.
Yes.
Okay. And in exchange for that, you got the capital murder charge pending against you dismissed, right?
Correct.
And you were allowed to remain out on bail this whole time, this past 7.5 years, right?
Correct.
And the agreement is that if you satisfy the terms of your deal, then you'll get what's called deferred adjudication, right?
Correct.
And you understand deferred adjudication means that you would not be finally convicted of that felony offense, tampering with evidence, right?
Correct.
Which means that if you successfully complete your deferred adjudication, you can petition a court to non-disclose the record, right?
Correct.
Meaning that other than police and perhaps the judge, the members of the general public that might want to employ you or give you an apartment or anything else would not necessarily know that you were ever convicted or never admitted guilt to defer tampering with evidence, right?
Correct.
And the condition for you getting this deal was that you would testify truthfully against Mr. McIntyre, correct?
Correct.
And you understand when they say testify truthfully, that the person who decides whether you're being truthful is the district attorney's office, right?
Correct.
So if they think that you're not telling the truth, then they would be able to tell the judge that, and it could impact your case in a negative way. You understand?
Yes, sir.
And you also understand that if you are placed on deferred adjudication, you're eligible for what's called early termination of that deferred adjudication, right?
Correct.
And early termination can be applied for the day that you are placed on deferred. You understand that, right?
Yes, sir.
So it means that if you testify to the prosecutor's satisfaction in this case, and you are sentenced to deferred adjudication, as you said in your agreement, you could apply for early termination that day. You understand that?
I'm gonna object as to relevance. It's a misstatement. He needs to read the agreement because that's not what it's contained in therein.
Your Honor, it's plainly part and contemplated of what a deferred adjudication is, and she knows what early termination.
But is it a part of the agreement? That's the state is saying that it's not a part of the agreement.
Does the agreement say that there's no opposition to it? You have 1 sentence. 160.
Yeah, and for you who just joined, we are on verdict watch. The jury is deliberating. In this case, we are rewatching the cross-examination of Cocaine Stripper Girl. The only witness in this entire trial who actually puts the defendant in the car.
Your attention, is the Elmo working?
It's ready. It's ready.
Yes, please, 9 and 10. Yes. All right. So on paragraph 9, it says the state will agree that at any time served on bond while awaiting sentencing, without violation of bond conditions, will count towards the deferred recommendation time, and the state will adjust the recommended time for deferred accordingly. For example, if your client, or you in this case, spends 2 years on bond from this date without violating the conditions, the state will recommend 8 years of deferred instead of 10 years at the time of sentencing. You read that part?
Correct.
And how long have you been on bond for this case?
Almost 8 years this month.
Almost 8 years this month. So the result of that is that if you have satisfied the state's expectation that you testify truthfully, at the conclusion of this, I guess you'll have to spend another year on deferred adjudication before you would be eligible to request that you receive early termination. You understand that?
Correct.
I'm gonna object to speculation and relevance.
Well,
All right, with
number-
regards
paragraph
to,
10.
with regards to speculation,
Well, Your Honor, I'm just asking her what her understanding of her own plea agreement is, which goes to her bias and motivation, which is an admissible question.
all right, could parties
been admitted.
approach?
There were a lot of sidebars in this trial. 38 of them in 9 days. And 19 motions for mistrial. It has been an interesting trial. Yes, let's just say that. Very, very interesting.
All right,
All right, defense, you may proceed.
all right, Ms. Reyes. So to go back to paragraphs 9 and 10 of your agreement, you understand you've been on bond for 8 years, right?
Correct.
And you understand that under this agreement, so long as you're testifying to the prosecutor's satisfaction, they're promising to give you a discount on the total 10-year period of deferred for each year you served on bond in their recommendation to the court for punishment, right?
For the truth, correct.
And that you must spend half of the total time on your deferred before you can apply for early termination, right?
Correct.
And that would only be a year, given that you've already spent 8 years on bond, assuming that the prosecutor does recommend that reduction and assuming the court accepts it, right?
Correct.
And you understand that there is no statute of limitations for capital murder, right?
Correct.
And so if you testified in a way that was not to the prosecutor's satisfaction, you understand that you could still be prosecuted for this capital murder offense, correct?
Correct.
And you understand that 10 years is the maximum for the third degree felony, correct?
Correct.
But it would be life in prison without the possibility of parole for you if you were to be charged with this capital murder offense, right?
Correct.
Now, when you first met with Detective Juarez, it was in September of 2017, is that right?
Correct.
So about what, is that, I'm not good at math, like what, 6 months or so after the offense?
Correct.
Okay. And during that time period, you said that you went to Dallas, you were in Ector County, which is Odessa for a little bit. That's where you got arrested.
Correct.
So you said that you met Taymor about a year and a half prior to this offense,
Correct.
and he was 15 years old at that time, wasn't he?
I didn't know his age.
Yeah, she claims she had no idea how old he was. He was her height or shorter and soaking wet around 90 pounds. He was a teeny tiny scrawny kid at 15. And she was at the time an 18-year-old stripper. Yeah. Can anybody spell statutory rape?
that time.
Well, I'm asking if you know that now.
Yes, no, I do.
He was 15 when you first met him.
Correct.
And he was 16 years old on the 23rd of August, of April in 2017, right?
He lied at that time and said he was 18.
But you understand he was 16 years old, right?
No, I do, yes.
Okay. You met him at a gathering through Isaac, which was your boyfriend at the time,
Correct,
but then you started dating Taymor in the 2017 timeframe, correct?
correct.
And you said that you were acquainted with Jeremiah Rodriguez because you went to high school with him.
Correct,
So you knew that Jeremiah Rodriguez was a drug dealer, right?
correct,
And you knew that he often carried weapons, correct?
correct.
You said at the time period you were dancing at a strip club,
Correct.
and the weekend of this incident, I believe, coincided with the Stoner's Holiday 420. Is that right?
Yeah. Weekend leading up to the incident was 420. During direct examination, she has already admitted that she used cocaine and marijuana. Let's see what she what she says during this
April 20th,
Objection, relevance, and
Relevance.
personal.
if you know.
Relevance.
Well, I'm trying, well, the relevance is, I believe, what they were doing at that party as it relates to what happened later, and it relates to,
All right, you'll need to lay the
Time frame.
foundation with regards to time.
was there a party the weekend of this incident that you attended with Mr. McIntyre and others?
That weekend, no.
Okay. But you and Mr. McIntyre and Mr. Bell were all hanging out.
We were together, yes,
Was Jeremiah with you?
yes,
But you weren't staying at Jeremiah's house that night before this incident, were you?
yes, we were.
Okay, are you sure of that?
Very sure.
Okay. If Jeremiah disagrees with you, Jeremiah is not telling the truth?
Correct.
Okay.
Yeah, and guess who the prosecution didn't call as witness? Jeremiah!
And you all took drugs that night before, didn't you?
I didn't, they did.
Okay, well, you say you didn't. Let's be more specific. They took LSD, didn't they?
Yes.
And you didn't take LSD.
No,
You smoked marijuana, though, didn't you?
I was completely sober.
You didn't.
Yeah, the one weekend for years she decides to be completely sober is 420. Yeah, sure.
Smoke marijuana or do cocaine?
No, not the day before.
Are you sure?
Yes.
But you had done them in recent time frame.
Previously, yes.
Okay. And so Mr. McIntyre and Mr. Bell would have taken the LSD sometime in the evening hours of Saturday night before this event on Sunday, right?
Correct.
Okay. And do you have any experience with taking LSD?
Yes,
You're aware it's a very long-lasting drug, right?
correct.
So it may not be that they were acutely intoxicated, but there would still be effects 24 hours later, you know?
Objection, speculation.
Sustained.
In your experience, you could still be having effects from it 24 hours after the fact, right?
Yes, but it didn't seem like that.
Okay, I'm not asking you what it seemed like. I'm just asking what your experience with that drug is.
Yes,
So that night before, there had been a conversation about a photo shoot. Part of that was to promote your career as a dancer, wasn't it?
no,
Okay. You say it was because Mr. McIntyre was wanting an album cover,
correct.
but you're aware that Mr. McIntyre has a producer and that he has people that do photo shoots for him and that all of those types of things?
Objection, relevant.
The claim from the prosecution and from her is that this was supposed to be a photo shoot for an album cover or something of the sort, which is slightly contradictory because she is the only one who had contact with the victim. And the cops never checked her phone. They only checked were there calls made, not communications, actual communications.
No.
And
All right.
speculation.
The state has objected to relevance.
Well, it's relevant because I'm just asking her if she's aware. It goes to whether or not she understood the framing of this correctly.
All right, that objection will be sustained.
So, you contacted Mark through Instagram, right?
Correct.
And Mark had contacted you previously on a different Instagram account of yours, right?
Correct.
And had asked if he could take photographs of you, right?
Correct.
And the kinds of photographs Mark wanted to take to you, I'm sorry?
I'll let you finish the question.
The kinds of photographs Mark wanted to take of you were either nudes or risque photographs, wasn't it?
Judge, I'm gonna object and if we get it.
Yes.
Yeah, the prosecution really don't want to know about the history between the victim and cocaine stripper girl. They really, really don't want the jury to hear that. Let's see.
Defense, you may proceed.
Right. So what we were asking a moment ago, Mark had reached out to you on a prior occasion, and the discussion was about whether he could take nude photographs of you. Do you recall that?
Yes.
And when you looked at Mark's Instagram page, you saw that most of his photography work was of that variety, naked pictures.
Yes.
Yes, the victim. What he did on a daily basis was searching for girls he could take nude pictures. Now, it was referenced, and I think we will hear about it soon, about some of these pictures being of girls who were not legally allowed to have nude pictures taken of them. And the defense had a witness. Sadly, that witness decided to lawyer up, and his lawyer said, yeah, he's going to plead the fifth. Don't even bother. Fun times.
And because of those things, you had blocked Mark previously, right?
Yes.
And then you had activated a new Instagram account, and that's how Mark got a hold of you on this occasion, right?
I had that account for a while.
Okay, but he resurfaced as an Instagram correspondent
Correct.
on a new account, right? And on this occasion, the discussion was displaying you in lingerie, correct?
Yes.
And so those were the circumstances that were going on during the evening hours of Saturday leading up into Sunday. We're making arrangements to have this photo shoot where you would be in lingerie, correct?
Correct.
All right. And you said, I believe on direct examination, that he had agreed to do this for little or no pay, right?
Correct.
And so you all were thinking about doing the shoot somewhere near the North Star Mall?
Correct.
Okay. And when you arrived, he walked out from his house and he got in the car and he saw that it was you, Jalen, Taymor, and Jeremiah, right?
Correct.
And that wasn't something you had explicitly discussed with him before, was it?
Here, I believe the defense made a mistake. They didn't put in, you claim that these people were in there. The defense said their client was in the car. A jury can remember that. Defense, you need to say this was your claim. You claimed that these people were in the car.
The fact that there'd be other men there, right?
He knew Taymor was gonna be there.
He didn't know anybody else was going to be there, right?
And we said multiple people.
Okay, when did you tell anybody that?
Or through text.
Let me
And we
back up.
communicated with him.
Let me back up a moment. You have given statements to the police in conjunction with this case, right?
Correct.
And you have given statements under oath when you entered your plea of guilty to the plea agreement, right?
Correct.
And you didn't tell anybody that you had explained to Mark that there would be a bunch of men present at the photo shoot, did you?
No.
So Mark gets in the car, and immediately, once y'all are rolling away, the photo shoot's called off, right?
He asked to reschedule for a later time that day.
Okay, that's calling
So he got in the car, and then when he was in the car, hey, let's reschedule. And she's the only one who says this because, yeah, for reasons.
off the photo shoot, isn't it?
It's rescheduling.
Okay, so y'all were still driving away with it, right?
Correct. He asked for a ride to North Star.
And you told the detective that you were confident Mark's intention was to have sex with you that day, right?
No,
You don't remember telling the detective that?
no.
Would it refresh your recollection to look at your statement to the detective?
We can. Number 9 or
Number 9. Reyes, I'm going to give you this transcript. I want you to kind of look it over. And if you have any questions that you would like to refresh your recollection from it, please let me know. I'll be asking you some questions from it too. We'll have copies.
Judge, I'm gonna object to that exhibit. It's not written.
I haven't offered it, and I'm just giving it to her because she said it might refresh her recollection, and if it doesn't, it doesn't.
You just need to know what it is. I don't even know what it is.
I was just giving you a copy.
I'm objecting to lack of foundation. It's not for.
I'm giving you a copy of it so you can tell me what it is. What do you mean it's not understand? Yeah. I'm not offering.
What happened here is that the transcript was not the official transcript. It was a transcript they took from the video interview. So they got the transcript themselves, but not through the court, which makes it a problem. I do believe the reason why they did it privately was because they didn't want the prosecution to know exactly what they were after. Problem is they were offering it as a transcript, but then it has to be an official transcript. Had they offered it as from that video, we elicited a private. They should have had a hearing about it. Let's just say that.
All right. Ms. Reyes,
Right,
if I-
so a party's approach.
And one of many sidebars. Ooh, that I. She has sleeves. And when I say sleeves, I mean tattoo sleeves. Doesn't mean that more than, well, she has a lot of tattoos and trying to hide them.
The witness's statement. State, have you had a chance to review that? Or have you seen that before today?
No, Judge.
All right, so this is what the court wants the state to do, review that. And if someone can show her defense, if you're saying this is a transcript of her actual video statement, is that correct?
That's correct.
All right, so if someone has her video statement, if you all will please show her video statement. And defense, whatever you want to cross, if it turns out it's for impeachment purposes, if you can do your time steps on her video to show that to her for any reason you believe it's impeachment evidence.
And if you are making specific to what this question and answer is about, I can call the witness's attention to the 50-minute and 39, or I'm sorry, the 50:39
All right, so
mark on the video.
here's the problem with that. If you all want to go to the video and specifically show her that portion, then if somebody will go to the video and show her that portion of the video.
I have that portion ready for the court, Your Honor, but I just wanted to, I mean, At this phase of it, all I have asked is if the witness recalls her previous statement, if it would help her remember to have a copy of her transcript in front of her.
But see, the problem is the transcript that you're saying that is her transcript. That's not an official transcript. My understanding, if I am wrong, correct me, my understanding is that is someone that the defense, I guess, hired, or someone that the defense had to take her video statement that she gave to, authorities and have them watch that and do a transcript of it. Am I correct?
Well, yes, but the problem is, Judge, we're talking about two separate rules of evidence and application. Right now, at this moment in time, all we're dealing with is past recollection refreshed. And if I had a cardboard cutout of Mickey Mouse that would refresh her memory, then I could show her that. That's all I'm doing, whether it's an official
Well, let me ask
transcript
you
or
this.
not.
So here's my question to you, because that transcript is not an official transcript. So you're trying to refresh her memory. So let's assume it doesn't refresh her memory. Then what's going to be the next step?
I'm going to ask her if she said on a prior occasion, and I'm going to recite what I believe she said. And if she says yes, then that ends the
But
discussion.
what if she says no?
Then we have the video clip to the
So
exact.
why don't we
timestamp.
just show her the video so we don't have to take the jury back and forth outside? So just show her the video.
May we confirm for a
Yes.
moment, Dan?
Yeah. Problem that arose from this is that they showed, and this is a ruling I do not agree with Judge Boyd on. They showed this witness the entire video, which may, in order to impeach a person, first they have to testify from recollection, and if they say absolutely not, then you can impeach. Now she was able to watch the video, and all of a sudden she might have better memory. Yeah, this is when the surprise gets robbed. Exactly, K-Pick. How can you impeach someone when they already seen it? Exactly. She's ready for questioning after seeing what she actually said back in the day. And I do not agree with Judge Boyd's ruling on this. Usually, I'm not sure about local rules or how she normally does it, but will this ham sandwich refresh your recollection? And if it does, it does. If it doesn't, it doesn't. So for me, it shouldn't matter if it's an official transcript or not, as long as she can say, does it refresh your recollection? Yes or no? And if she says no, okay, now we have to go to the video. And I understand that Judge Boyd doesn't want the jury to be in and out, but the alternative is what happened here, that the witness got forewarned. And yeah. And here is the issue. That was the end of that day, not of cross-examination, but they showed her the entire video.
Going to start tomorrow at 1:30. On Wednesday, we're going to start at, on Wednesday, we're going to start at 9 a.m. Thursday, we're going to start at 9 a.m. Friday, we're going to start at 9 a.m. All right. And I've had my docket for Thursday. That's going to be moved. So, all right. So you're welcome. So I want her to continue to watch her video. We want that done. So when we come back tomorrow, we need to watch a video or something. And if you all have any stipulations, I overheard you all saying you may have stipulations. If you all could get that done as well for the court. Okay.
I like this on the record.
Yeah, we're on the record.
Okay.
Well, if it's
That's all right.
counsel, Your client is here.
Yes. If we could have the court instruct.
Oh, she was
If we
ready.
could have, we were like, the court to instruct the state, which I think they know otherwise anyway. Not to discuss or testimony the other show the video.
Yes.
During the break, since she still wants.
Oh, no.
And they-
That's why, and I know they're not going to do it, but that's why I wanted a defense counsel in the back with her while she was watching the video.
Tomasi.
Yes, yes.
Yeah.
So that's why I did that. But so she's still under oath. You all know that. And so she's still considered to be in the middle of her testimony. So no one is allowed to discuss with her testimony. So please, no one call her and say, let's discuss this, because she's still
And the
under
same-
oath.
You know that issue earlier this morning or yesterday was granted cert in the Supreme Court.
Mhm.
And it was Ed Shaughnessy's.
Yeah.
And he's got
Access to the defendant
yes.
in Jefferson Marshall. Yeah, I saw him one night.
By the way, I got him.
Oh, just one second. We're off the record. We're now just, they're just now just
Cities just copied that.
chatting about other things.
Here.
Okay, and let's go now to the next day, where cross-examination continues. Yeah, I am constantly checking George Boyd's YouTube page,
All right, everyone, please be
just in
seated.
case the jury comes back early.
All right, you're
or have a
still
question.
under oath. And if you could just restate your name for the record, please.
Joanna Reyes.
All right, make sure you keep your voice up so that members of the jury can hear. All right, defense, I believe it's still your witness.
Thank you, Your Honor. All right, Ms. Reyes, when we left off yesterday, I had asked you if you had previously told the detective that you knew that Mark getting into the car had the intention of having sex with you. Do you recall that question?
No, sir.
Okay, well, let me ask you again. When Mark got into your car, you knew that his intention was to have sex with you, right?
No, sir.
But that's not what you told the detective, correct?
No.
You had an opportunity to review your video yesterday after court
Yes, sir.
in its entirety,
Yes.
okay? I'm gonna call your attention to about 50 minutes and 39 seconds into that. Mr. Lane, if you could get that queued up for us.
Yeah, I see here. Auto doctor, what was the witness that backed out for? He is cocaine stripper's ex-boyfriend who she had after this event.
Toothbrushes are all over. Okay, so everybody had a toothbrush?
The ones that was normal was mine,
What do you mean all?
but because they had vibrating toothbrushes, the ones that like.
So the vibrating ones, or they have-
Theirs.
Okay, all right. I know it's gonna be kind of a stretch for you to remember, but you said that the guy had a roll of condoms?
Yeah.
What color?
I
No, I don't think you're.
didn't look back.
Did you see the roll?
I didn't see it.
Did you see the lube?
I didn't see none of it. They just said it.
So what did they say?
They just said, were you trying to rape her and this and that? Or maybe I did see her show me the roll of condoms, but that was it. And I don't know if they're black or gold, I can't remember, but he was just like, were you trying to rape her and this and that, and that was it. And that's the only thing.
Let me ask you, do you think a dude had some condoms in his backpack? Sure.
No, he just thought he was in a book. That's just that, of course, men, some men. That's of course some men, like, I didn't think that far into it, but that, that was just, I even, like I said, I never looked back, I never looked to the side, nothing. I was scared.
So you told the detective that he thought he was gonna fuck, right?
Because he was interpreting that
I'm asking you that you interpreted him as having interpreted he was planning on having sex with you, correct?
Because he said that.
And you saw that there were in fact condoms in the man's backpack after this was all over,
I
right?
never saw anything that was in the backpack.
You heard the portion where you said that Taymor showed you the condoms, right?
Yes, but I didn't see anything else that was in the backpack.
And the reason why Mark thought that he was gonna have sex with you is because that's what you led him to believe, correct?
Speculation, she can't
know.
testify to what.
There's nothing speculative about what she previously said.
Approach.
It is kind of speculatively, but this is a hostile witness. They should be able to ask rough questions.
Ask your question and then state, if there's an objection to it, you can make your objection. And I'll give the defense a chance to respond to that objection and I will make a ruling. So ask your question, defense.
Mark thought he was going to have sex with you because you had led him to believe that's what was gonna happen that day, right?
No, sir.
Objection. Speculation.
All right. The objection, the witness has already answered. Ask your next question.
Thank you, Judge. Yesterday, to recap, we talked about the fact that Mark had tried to contact you on Instagram some time back before this incident, correct?
Correct,
And he had contacted you, right?
correct,
And that resulted in you blocking him from your Instagram account, right?
correct.
Because his account was largely pornographic in nature, right?
Objection, that's been asked and answered, and speculation.
All right, that'll be, the objection to asked and answer will be overruled.
You can answer the question, ma'am.
Correct,
And after you blocked him, you created a different Instagram account, correct?
yes.
In fact, you've created several different Instagram accounts over the years, right?
No, sir.
You've only created one new Instagram account?
I believe so. I'll change the username for my safety, but I only have one other.
Okay, but so you've changed the username multiple occasions, right?
Yes, sir.
And so you eventually, through a different username, made contact with Mark again, or he made contact with you? Which was it?
I messaged him.
Okay. And you discussed doing a photo shoot, right?
Correct,
And you and he asked you about doing the photo shoot in lingerie and underwear, right?
correct,
And you advised the detective of this fact and the fact that you knew that that was the kind of photography he was into, correct?
correct.
And so when Mark showed up at the car, he was surprised to see that there were all these other people in the car besides you, right?
No, sir.
But that's why he called off the photo shoot, wasn't it?
He said he had to reschedule because he had another person.
But he didn't text you that, did he?
No,
He told you that in person inside your car after you all had driven to pick him up for the photo shoot, right?
correct.
So the only thing that had changed between the time that you talked to him before and the time he got in your car was that there were 3 dudes in the car with you, right?
Can you say that again?
The only
Or
difference
repeat it?
between when you arranged for him to meet you for this shoot and when he got in the car was that there were 3 dudes in the car, right?
And there you have my foundation for my theory is she set him up. She might not have set him up to be killed, but this reeks of setup. Hypothetically, as you heard, he had been trying to contact her for quite some time. She blocked him, then created a new Instagram account, then they got into contact again. Well, this was at the time when she wasn't 18. Also known as a minor. Or even below 17, which is the legal limit, legal requirement in Texas, something of the sort. This victim was known for trying to contact high school girls, minors, apparently. Now, that was sadly not allowed to be brought in front of the jury. Because reasons. But maybe if the defense would have argued motive and an alternative series of events. But trial is, well, everybody has said their piece. And now it's up to the jury.
There was people there.
Let me ask you a question. Can I approach, Your Honor?
Yes.
I'm going to show you what I marked as Defendant's Exhibit 10. Do you recognize that photograph?
Yes,
Who are the people depicted in that photograph?
my ex-boyfriend,
And you?
yes.
I object to relevance, Your Honor.
All right, if I could see,
Foundation.
if I could see the exhibit, please.
My ex-boyfriend.
You were dating Mr. Horace in roughly 2018 until 2021, something like that?
Objection, relevance.
Sustained.
How long were you dating Mr. Horace?
Objection, relevance.
Sustained.
Did you spend time with Mr. Horace after the date, after April 23rd, 2017?
Objection,
Yes.
relevance.
That will be
Your Honor,
overruled.
I have to be able to ask.
I
her-
said the objection is overruled.
So you spent time with Mr. Horace after the offense date of April 23rd, 2017, right?
Correct,
And it was a lot of time, correct?
correct,
You actually at one point moved to Houston to be with Mr. Horace, correct?
correct.
And during that time period, you discussed aspects of
Yeah, she tried to claim they weren't in a relationship, they weren't dating. They moved in together.
this case and your involvement. Do you recall that?
No,
Did you tell Mr. Horace that
Objection, calls for hearsay, both hearsay and improper impeachment.
it's not improper impeachment? Under 613, I have to confront her with the substance of her prior statement.
Objection is sustained.
Oh, we're going to take a vote in a second. Hold on.
This is one of these because she is
You
technically
testified a
a
moment ago
party in this case.
that-
What she said to other people, but then again, they need to lay the foundation and all of that, and have some impeachment material.
Mark knew that there would be men in the car with you, correct?
correct.
But that is not what you told Mr. Horace, is it?
Objection, hearsay.
That'll be overruled.
That is not what you told Mr. Horace, is it?
I never told him anything besides that I had a case.
You never told Mr. Horace that you intended to get Mark to come for the photo shoot along with you?
No, sir.
Now, you testified previously that you did not know Mark except as an acquaintance on Instagram, correct?
Correct.
But that's not what you told Mr. Horace, is it?
That is not true.
You've told Mr. Horace that you've known Mark since high school, right?
No, sir. I knew him because of high school. He was older than us.
That's what I'm asking. Because of high school, you knew of him?
Of him, correct.
And you also told Mr. Horace that he had tried to violate you on a prior occasion, correct?
No, I did not.
And you also told Mr. Horace that you didn't tell Mr. McIntyre or any of the other people in the car about this past interaction with Mark before getting in the car with him that day to pick him up, right?
No, sir.
And you also didn't tell Mr. McIntyre or anybody else that you secreted a gun underneath your seat in the car when you went to go pick him up that day, right?
That is not true.
You also didn't tell Mr. Horace that when he got in the car, you told everybody in the car about the fact that Mark was a pornographer and that he had done creepy things and that he had tried to do creepy things with you while you were in high school, right?
I never said that.
And you also didn't tell anybody in the car. Well, let me back up. You told Mr. Horace that when Mark told you that the photo shoot was called off, there was a demand to look into Mark's backpack to see if he really was a photographer, right?
No, sir.
And you told Mr. Horace that when you looked into the backpack and there was an examination of this camera, that you found child pornography in it, right?
Objection,
No, sir.
objection, relevant.
Sustained.
Approach, please.
Yes, you may approach.
Yeah. Now this trial became a clusterfuck. Because at this time, they believed they had her ex-boyfriend lined up for defense case in chief. But somehow, just a day later, just the night before the defense case in chief and he was supposed to testify, he, for some odd reason, decides to lawyer up and plead the fifth, if he was ever being called as a witness. Which is strange, because if her ex-boyfriend contacts the defense, why did he change his mind? Was he watching the trial? We don't know. Problem here is we don't know a lot of things. Now, I do believe that the defense had a recording between Mr. Horace and their investigator. Apparently that wasn't enough. They needed him there as a witness to testify anyway. And then he lawyered up. Which is really unfortunate for the defense. They didn't send a subpoena because they thought he would be there voluntarily. And then he changed his mind. But even with that, when they said the CP word, that is highly prejudicial towards a victim. Because the only way they could get that information out was through her ex-boyfriend.
A motion in limine. All right, defense. The state filed a motion in limine. Defense, you were aware of the state's motion in limine. And I informed both parties, either side, if you have a motion in limine, before you enter into any territory that's the subject of the motion in limine, that you approach. And the reason why I do that is because, as both parties know, I do not know what the evidence is in your case. I don't know any facts of the case. I'm hearing this case as the jury is hearing it. And in the state's motion in limine, on page 2, it states, the state requests that the court grant this motion in limine and instruct the defense counsel to approach the bench and present the proposed evidence outside the presence of the jury before voir dire, opening statement, questioning, or in any matter bringing any witness or evidence of any of the following matters. And the number one thing says, any crimes, wrongs, or bad acts of the victim, Mark Anthony Saldivar. So, defense, it appears to the court that you've violated the motion in limine, unless you're going to try to tell the court that possession of child pornography is not a bad act.
Your Honor, what I'm trying to elicit from the witness.
No. The question is whether or not you were aware of the motion in limine, which you were, and whether or not you violated it in regards to violation of condition number 1. What you're trying to do with the witness, and excuse me, I'm gonna have the witness step down. And counsel, you'll take your client to the back. You're still under oath and the rule has been invoked.
And the witness has weird cry sessions here and there. Yeah, now she starts crying. And yeah, LeSean, Judge Boyd isn't playing. She does not play. And there was a motion in limine. Had the defense known back then, because this is an old motion in limine, had they known what would appear later through this witness? But then again, they should have motioned anyway. Judge, we are going to bring this up. And this is how we are going to bring it in. And here are the reasons for it. So yeah, they did fuck up with this.
Photos of child pornography that you're saying that the complainant had, then you're just throwing questions out and you're violating the motion in limine. It clearly states that you all are supposed to approach. Now, unless you all think that child pornography is not a bad act, then I don't know why that's a crime. Because if you're saying it's not a bad act, you asked this witness a question and it involved child pornography. Did I hear that incorrectly?
You heard that correctly, Your Honor, and I'd like to also make aware to the court yesterday when we approached about my motion in limine, the court specifically regurgitated condition number 1 to defense in regards to the nude photos.
Your Honor, I understand that the court is of the opinion we violated the motion.
No, not of the opinion. You violated the motion in limine. The motion in limine says that you are to approach before questioning or in any matter bringing any witness or evidence of any of the following matters: any crimes, wrongs, or bad acts of the victim, Mark Anthony Saldivar. And you're asking this witness about whether or not he had child pornography or something in his camera. The court considers that a bad act.
Your Honor, to be clear, the questioning of the witness is intended to establish whether or not she previously made these statements. They're not being offered under Rule 613 for their truth. They're being offered for what she said to another individual.
You are still, what you're questioning her about is a bad act that she said that was the bad act of the complainant. And that's a motion in limine. And you all should approach before you do that. You violated the motion. The court is finding that you violated the motion in limine. And the only question now is, how is that corrected? Because nobody approached the court to say, I'm going to start asking questions that is related to number 1 to the state's motion in limine.
I understand the court's ruling. I've given my explanation for it. As far as the remedy is concerned, the court will do as it sees fit. I understand.
I know I am. But you're still, it appears to court, acting as though you haven't violated number 1, and you have. You violated that motion in limine.
Your Honor,
And I can tell you, yes, counsel?
I think we're slightly, we understand the court's ruling. However, I do want the record to reflect, at least, that what we're asking is what the witness's previous statement. We are not accusing anybody of anything, and we're certainly not trying to accuse Mark, and we will be happy to explain to the jury.
It's still a violation of the motion in limine. Hypothetically, if somebody were to ask for it, any defendant, not just your defendant, if somebody were to ask a witness on the stand, hey, by the way, and didn't you tell somebody else that the defendant had possession of child pornography, the defense would be objecting because it's a violation of the motion in limine. It's a violation of the motion in limine in fact and in spirit.
Well, it is intended because this witness gave a number of prior statements. One to a police officer during an interrogation, which was video recorded. Another under oath before another judge in a different courtroom.
But here's the thing, it doesn't,
I'd
it
like-
doesn't matter to the court. What matters to the court is that it's a bad act, and all you all had to do was approach the court. I would have heard it, what you are seeking to get from this witness, and I would have made a ruling on it. But
I'm-
instead, you have people who are violating rules, and I'm finding you violated the motion in limine rule. It's not supposed to be brought up until it's brought up to the court outside the presence of the jury. Now, what you have done is by bringing this up, I don't know if the jury's going to believe he was in possession of child pornography or not. I don't know if he was in possession of child pornography or not, because nothing has been presented to the court. And all you all had to do was approach the court and said, Your Honor, I believe we're going to go into number one of the state's motion in limine. And you know what I would have done? I would have had the jury step out and I would have said, okay, what's the issue here? And you would have told me that and I would have made a ruling.
I believe this came up yesterday.
No,
Yes.
Not the possession of child pornography.
The question of photographs on the camera of,
of nudes.
right.
That's it, of nudes. And when we were here at the bench, I even told the state, okay, he has nude photos, allegedly. I said, how is that a bad act? Having a nude photo is not necessarily a bad act.
I see. the
And
question.
both parties said, yes. Mr. Hunter, yes, Judge, you're right. It's not a bad act. And then we go a step further today, and now it's possession of child pornography. And I'm not going to allow you all to ask that question. And I'm going to instruct the jury to disregard.
We understand, Your Honor.
We understand. And there are some additional matters that she spoke of that have nothing to do with nudity or pornography. And
what would that be?
Your Honor, I don't believe that any other bad acts or potential bad acts of Mark Anthony Saldivar will be discussed other than those things which were discussed in opening statement related to the.
I'll determine whether it comes in or not. And you know why I'm going to determine whether it comes in or not? Because there was a state's motion in limine that says any crimes, wrongs, or bad acts of the victim, Mark Anthony Saldivar, you'd approach beforehand. And I need to make a ruling on whether or not it's relevant and whether or not it should be admissible. That's me. That's my job.
I understand your.
So what other acts or what other bad acts that you feel, crimes, wrongs, or bad acts of the victim, Mark Anthony Saldivar, that you feel this witness is going to be questioned?
I can tell the court that it's going to be, and I don't know if it'll be disputed or not, that he damaged the vehicle. I guess that could be considered a bad act. I want to.
Well, with regards to the damage of the vehicle, allegedly, it said that he put his foot through the glass of the vehicle. That's a part of this whole alleged offense and the offense date. So, counsel, you all know that if there's evidence that's going to come in that he damaged the windshield, that's already in through other people.
Right, and the issue of what she said, back to that.
Yeah, at one point, defense should have just accepted, moved on, because this was just taking time. And you don't know, because since they brought it up, and the judge then told the jury to disregard everything about it, what was their reaction? Because it could be very prejudicial towards the victim. But if the judge tells them to ignore it, they might as well, okay, the defense lied. Because they never heard anything about it again.
To our client, she says that she didn't say anything, that she looked straight ahead, didn't look to the side.
All right,
didn't look
so
behind.
here-
May I just finish?
We're getting off track. We're with the bad acts.
Well, I'm gonna suggest that she has told people, and I believe if she says that's correct, that I never said anything other than that, to Mr. McIntyre, part of the race just of the offense, if if she said something other than what she told the police officer, I believe that's a prior inconsistent statement, and we're entitled to ask her about it. And by the way,
I'm
it
not
has nothing
challenging-
to do with
I'm not challenging,
pornography, sex, anything else.
counsel, I'm not challenging anyone on inconsistent statements.
Okay.
I'm not challenging anybody on that. The court knows the rules of evidence. What I am saying is there's a motion in limine. And I think it's safe to say for the people who have been practicing even a year that you know you're not supposed to violate motions in limine. And number two, if there's an alleged offense and videos have been shown in exhibits that it's alleged to be, or maybe the jury feels it's already been established that the person who kicked in a window or damaged the window of a vehicle is the complainant, because witnesses have said it's the complainant who did that. So you all know questioning the witness about that, that's really not about the motion in limine. The
That's
motion in
what we're going
limine is about your co-counsel violating it.
My able co-counsel, I can tell you if I can get 5 seconds, I believe he will go into next the matter of what was said that precipitated the fight.
All right, let me
And
just-
I don't think it's about anything, and I think we're entitled to ask the witness.
Yeah. Now, the theory here from the defense might be valid. Because they picked him up and then they started driving. All of a sudden, they are rummaging through his backpack. And if he actually has bad pictures of minors, he would fight as hell to get that backpack back. So I believe this is a part of the defense theory. Problem is, you need to lay all the foundations and ask the court's permission before. You can't just spring stuff like this. Is it a valid theory about why did they all of a sudden start fighting in the car? And it might be because the camera was never retrieved. Which is also weird, because why throw it away if you know the victim had bad pictures in it? I don't know. It's a clusterfuck. I'm very good at picking trials that turns out, even with a good judge, they seem to still become clusterfucks.
Let me just tell you,
Yeah.
you violated the motion in limine.
We got,
You will not ask this witness any questions about child pornography on a camera unless you have
we agree.
proof
We're
that
not-
there's child pornography on a camera.
Well, by the way, we do have proof of that,
Mhm.
and it was a legitimate question. However, the court's ruled on it.
Problem is, their evidence is the ex-boyfriend, and he lawyered up, and he never testified.
That's not what I'm discussing. I'm
at-
talking about what we're gonna do next.
At the time,
And
they believed
I don't
they
can't
had
look
it.
into his mind. I presume, since the court has ruled on it, we can make a bill later, but we're not gonna do anything in front of the
Yeah.
jury. However, I do believe conversation, what she tells the police officer, what she tells the judge, if there's somebody that says you said something else, I believe that's fair game, that's impeachment. And all I don't wanna do is, we shouldn't have to have the hearing like this before we ask every question.
No,
And if it doesn't involve child pornography or some extraneous offense, I think we're
no,
entitled.
you all have to have a hearing because it's a part of their motion in limine.
Not
you can't
if it's
just-
not an offense.
Here's,
Or
yes,
misconduct.
and the last time I checked, possession of child
And we
pornography.
agree.
It's an
And-
offense.
And we're gonna be chastised and the court's gonna do something.
Oh, no, my chastisement is just stating the law. There's a motion in limine in place and the defense has violated. And I am not going to allow you to ask questions about child pornography.
We're not gonna do that based
All right.
on the court's ruling.
Let's
However,
wait
we
the
should be
jury-
able
Your Honor,
to.
just in anticipation, the only other aspects of this questioning that I believe will venture into territory that the state might object to would be questioning about whether or not she had a hand in getting the gun into Mr. McIntyre's hands, if that is in fact what happened. And secondly, whether or not she is the source of the marijuana, which I'm not clear on.
All right, so here's the thing. And let me just tell you, this is what well, I'm going to say this.
She was asked that.
This is what I'm going to say, and I want you all to listen to me clearly. Both sides have been practicing law for more than 2 seconds. Everyone here knows that if you're asking questions and those questions are related to what's already been brought in evidence, the marijuana, it's already in there. It's already in the evidence.
Yeah, oh, by the way, we never got the answer to that. Why was the victim found with a bag of marijuana in his mouth? Nobody stepped out of the car to approach him. They drove off. How did the victim end up with a bag of weed in his mouth? We actually never found out. There was no testimony about why. I mean, did a random person run up and put a bag of weed in his mouth? Did he have weed on him that he decided to put in his mouth? I had no idea.
Who had it, what they did with it? Yeah, you can ask questions about that.
And guns.
What?
And guns.
The gun, it's already there. But I don't want any deflections where people are pretending as though they don't know that they violated the motion in limine. So I'm bringing the jury back in and I'm telling them to disregard the last question. I'm telling them to disregard any testimony or questions about child pornography. Does everyone understand?
Yes.
And the defense, you violated the motion in limine.
No, not edibles. Weed. Snivel says cops planted it on him
Oh, if you
out
could
of
have the witness
reflex when
take the
they
stand,
arrived.
please.
Yeah. He had a bag of weed in his mouth.
Your Honor, may the record reflect that the witness was not in the courtroom while those discussions were happening?
Yes.
Thank you.
Just 1 second, they're gonna bring the witness back in. You can bring the jurors in.
All right, for the jury?
And if you're wondering, I have this. I refresh. And and the moment there is a live on, we know something happened. It might be a jury question. As of now, I believe they have been. Well, if you take away the lunch, they have been deliberating for roughly an hour, I would say. And yeah, there were a lot of sidebars. 38 of them in a 9-day trial.
Nap. All right, ladies and gentlemen, the last question that mention the words child pornography, you are to totally disregard that question. Does everyone understand? Is everyone able to do that? You are not to consider it for anything. You are to totally disregard the question. And I don't believe an answer to the question was made, but if an answer to the question was made, you are to totally disregard that answer as well. Does everyone understand? Is everyone able to do that? All right, defense, you may continue.
Thank you, Your Honor. Ms. Reyes, you said that you didn't see anything other than the condoms that were shown to you, correct? In terms of the contents of his backpack?
Correct.
But you told the detective that there was a roll of condoms, lube, and a new outfit in the backpack, correct?
That's what Taymor said.
Okay, and you believed that, right?
No, I didn't.
Again, they are. How they ask this question is based. They should have rephrased every type of question here with according to you, because if they are not careful, they will more or less admit that Taymor McIntyre was in the car during all this. I believe it's a mistake.
believe anything.
You didn't tell the detective you didn't believe anything.
He asked me what was in the bag and I said what was said to me.
So when you explained it, you were explaining it in terms of what someone else told you, not in terms of what you believed to be in the bag?
Correct.
I'm gonna call your attention to this segment of your statement.
And he was like, give me all your shit, this and that, and then, so the guy doesn't wanna give him his stuff. And I was just like, what are you doing? And then he was just like, just shut up, and he was like, give me your stuff, and then they started pulling this backpack away from him, and then that's when they opened it and saw all that stuff.
So what was in the bag? You said-
There was a roll of condoms, a lube, a bottle of lube, and a brand new outfit.
And Judge, sorry, just for the purposes of the record, what portion was that? I don't know what,
I'm so sorry.
yeah, the VLC player members.
I believe that's at 1641.
1641. Thank you.
So when Mark gets in the car, he says in your words, he wanted to reschedule the photo shoot, right?
Correct.
But you proceeded to drive away from his house anyway, with him
He
in the
asked
car.
me for a ride to North Star.
Okay, so you were driving him to North Star Mall, which was where you were going anyway, right?
Correct.
And that obviously caused confusion in the car, correct?
Objection, speculation.
Sustained.
When he told everyone in the car that he was going to have to reschedule the photo shoot, there was a question in the car as to whether or not he was even a photographer, right?
No,
Objection,
sir.
hearsay.
That would be overruled.
And that was when the demand was made to see the inside of the backpack, correct?
No, sir.
And it's then that the men found condoms and lube in the backpack, right?
I never saw it.
And again, Mr. McIntyre was your boyfriend at the time, right?
He said I was his girlfriend.
Okay. You weren't dating Mr. McIntyre at all? That you don't recall your testimony from yesterday?
Yes, I recall it, but he would call me his girlfriend.
Okay. You were dating him, right?
So he says.
Okay. You dispute that now?
I always said I was never wanting to date him.
Okay. You recall your testimony yesterday,
Yes,
and you recall saying that you were his girlfriend yesterday.
yes.
Okay. So when they find the lube and the condoms in the backpack, that's when a physical altercation breaks out, right?
I never saw it, but yes.
And that's when you handed Taymor a gun, right?
No,
That's what you told Mr. Horace, correct?
no.
And eventually, as the struggle continued, that was when eventually Mark was ejected from the car. He was thrown out of the car, right?
I asked them,
I have to say, my tactic throughout this would have been they can't prove he was in the car during this altercation. Just because a person was seen with a white shirt. Just because this, just because that, because all they have is this person. But here they are. Hey, you handed him the gun. That's what you told him. That's... Yeah, that's not good.
to let him go after they were beating him.
And when we talk about they, Jalen Bell and Jeremiah Rodriguez were in the backseat of the car with Mark, right?
Correct.
They were the ones who had the easiest access to hit Mark, right?
So did Taymor.
Okay, so you described that Mark would have been sitting directly behind Taymor, correct?
Yes.
Okay. And so when Mark gets out of the car, he jumps on the hood of the car, right?
Not immediately.
Right, he tries the doors to get back in first, correct?
Correct.
And then when that doesn't work, he jumps on the hood of the car.
Correct.
And while he's on the hood of the car, he begins to stomp the windshield, right?
Once we were in the Chick-fil-A parking lot, when Taymor told me to drive the car back and forth.
Objection non-responsive.
Overrule. You can
Finish the
answer.
question. Answer.
That's when he smashed the windshield.
Okay. And he was kicking the windshield, right?
He kicked it once.
And you said he was kicking the windshield at you, correct?
He kicked it.
If she claims he only kicked the windshield once and it not just broke or got the spider web thing, it caved in. That is a hell of a one kick, if that is actually correct.
Once.
I'm asking you, have you said previously that he kicked it at you?
I don't know who he was kicking at.
According to most people, the victim was in the middle back seat. And everybody in that car points their finger at Taymor. Everybody else in the car got a plea deal. She was the only one who testified for the state. Yeah. Do you consider her credible? Yeah, how did he get out if he was in between two guys? How did he get out of the car? Sasha says, I like your stream, Nick. Thank you so much. I do my best. Yeah, sorry. Lou is correct. Two of them got a plea deal. One wasn't even charged.
Roughly minute 7:05 of the interview.
But what happened was, the guy that I had, Taymor, Taymor.
Yeah, that's correct, Derek. Someone said she was in the back seat as well. There are people around, eyewitness testimony, that there was both a female driver and a male driver. That the person sitting in the front passenger seat was Hispanic or an African American male. And not only that the person in the front passenger seat, one of the people said she saw a guy with a big afro with a white streak in the afro.
I just took to Instagram because he wanted us to get a photo shoot. So that's what we're messaging about. Then Taymor would take my phone and he was talking to him. Like, Taymor had my phone the whole entire time. I barely got to talk to my mom, anyway, so one day he was just like, okay, we're gonna go pick him up so we can have our photo shoot. I said, okay. So we went and picked him up. He asked me if I could just give him a ride to North Star, and I was like, okay, that's fine. And so we were going, and out of nowhere, we were at a stoplight, and Taymor takes out a gun and tells me to go back everything. I didn't know this was gonna happen. I swear on everything, I didn't know this would happen. And
Yeah, she's completely innocent. Everybody sat quiet in the car, and then they jumped him. Auto Doctor, what was the later boyfriend of the stripper supposed to be saying according to the defense? Well, he was going to testify, if I interpret the defense correct, about things she told him happened. including but not limited to, guy had CP, guy, the victim did something bad to her when she was in high school. A lot of things that she supposedly told him, but he never got to testify because he lawyered up and said he would plead the fifth. For some odd reason.
They all just started fighting. And I'm at the light and I'm like, I don't know what to do. I don't know what to do. And I was like, please just let him out, just let him out. And they were pushing him out. And I think Taymor grabbed his backpack and opened it and took out everything inside of it. And what we found was a roll of condoms, a bottle of lubricant, and an outfit. And he was like, just get him out of the car, get him out of the car. So they were pushing him out of the car, and he was like, no, I'm not going anywhere. And he was trying to get back in the car, and they were trying to push him back out. And the light was still red the whole entire time. And I was just there, like, I don't know what to do, I don't know what to do. And Taymor was just like, shut up, shut up, shut up. And I was just like, okay, and I was just at the wheel. And then when we were pushing him again, the lights finally turned green. I was like, okay, this is my chance to get away from this dude. So, and then he jumps on my hood. And I was like, oh my God, what do I do? And I still didn't know what to do. Taymor was like, keep driving. And he pointed the gun at me. He was like, keep driving, keep driving. And I was like, no. I was like, and I was just on the highway, so I'm getting away. And he was like, no. He was like, pull over somewhere. So I pulled over and they had me get Chick-fil-A. And the guy was just kept stopping on my hood and everything. I was trying to back up so he could get off my car. And I didn't know what to do. Like, I really was just going back and forth because I didn't know what to do. And then I said something and he kicked it through. He started kicking me through the windshield, and then when Taymor did that.
What did he do?
He shot him.
So you told the detective that he was kicking at you through the windshield, right? You also told the detective that you said we found condoms and lube in the backpack, right?
I said that, but I never saw it myself, and I made that clear afterwards.
And in the course of that, roughly slightly after 8 minutes and 25 seconds into it, you say the phrase, and he pointed the gun at you. And I just want to get a sense of this. During the exchange, when Mark is on the hood of the car stomping, you told everybody in the car that you thought he had a gun, right?
No,
That's what you told Mr. Horace, though, right?
no, I didn't.
And that you were yelling, he's got a gun.
No, I did not.
That's when Taymor shot him, right?
No,
You originally indicated that you didn't know whether anyone had a gun in the car when you got in the car that day, right? You remember telling the detective that?
I said that Taymor and Jalen always carried them.
Okay, so you don't remember telling the detective that you didn't know anyone had a gun when you got in?
No.
But then later in the interview,
Derek asked, Justin asked, where's the physical evidence? Well, the lead detective was satisfied with a shell casing was found beside the body. That way he determined it was a 9mm. And then listening to the witnesses, and then after a while, when she to him first claimed she wasn't there, and then she told lies upon lies upon lies upon lies, all up until she said, oh, it was Taymor who did it, and this is how it happened. And so there is no testing of DNA. There is no testing. They went with Taymor's phone was found in the glove box. We have no idea of knowing when it was in the glove box, or if he had several phones and he left one in the glove box. None of that was checked out. By the lead detective was very, very satisfied with, this is enough. no need to actually check the physical evidence further. They didn't even conduct a search warrant on any of these three people's houses or homes. Yeah, oh yeah, as Derek says, the first crime scene investigator, Ms. Wong, identified that shell casing as a 40 caliber, not a 9mm. The next CSI did a better job because Ms. Wong quit the force and is now unavailable.
You're asked about what gun Jalen Bell was carrying, and you specifically told the detective he was carrying a 9mm, right?
Yes, that's what he always carried.
So he was always carrying, but you charged the guy who wasn't caught with the gun, whose DNA was not on. But yeah, they never checked DNA on the shell casing or fingerprints or anything. Yeah, as auto doctor, what difference does it make what shell casing it was if there was no gun to match? No gun or no bullet to match. They found a 9mm gun, but it wasn't a match to that shell casing. They don't even know, besides it being next to the body, they don't actually know if it was a 9mm bullet, because they found no bullet. Brooklyn, did the jury come to a verdict? No, we are still waiting. They are still deliberating.
At the back, the shooting, as you're driving away, Jalen Bell had the backpack, right?
I don't know who had the backpack.
And you know that it was Jalen Bell who threw Mark's cell phone out of the car, correct?
So he said,
Okay, you didn't believe that?
I never saw it.
Did you tell the detective that Jalen threw the phone out of the window?
Correct.
And you know that it was Jalen who went through the wallet. I believe you testified to that fact yesterday, correct?
Correct.
Now, I want to get something clear. You testified that Mark got into the car with a backpack and a camera. Do you recall saying that?
Correct.
Was the camera in the backpack or was it separate from the backpack?
I never saw.
You never saw a camera,
I knew he had a camera,
but,
the photographer.
but you say you didn't see it.
I didn't see if it was outside the bag or in the bag.
Okay. What's in Ector County? Odessa?
Yes.
What's there?
Objection relevant.
What's the relevancy?
He was apprehended in Ector County.
All right, objection sustained.
Where did you go? Where were you when you were arrested for this?
Odessa.
Okay. Why did you go to Odessa?
Objection relevant.
Overruled.
Taylor's friends took me over there.
Okay. Which friends?
Deja and Keon.
Okay. They gave you a ride?
Yes.
Did you have any family there?
No.
Did you have any connections there?
No.
Okay.
In any other trial, that would have been presented as consciousness of guilt. But not in this one.
After this incident, and after Taymor and Jalen left Jeremiah's house, you never saw Taymor again, right?
No, only the baseline.
Okay. But you often told others that you were unable to get a hold of Taymor on FaceTime, right?
Not true.
Okay. You weren't upset that Taymor wasn't responding to you or answering your phone calls?
Not at all.
You remember that you were at one point concerned that you might be pregnant and you were trying to reach him and you couldn't get a hold of him?
No, they're manipulating me to think that I was.
And now this cocaine stripper who likes to be a girlfriend to a minor boy says that other people convinced her she might be pregnant. I don't think she's that stupid. Now, I don't think she is a brainiac. But how do you get convinced by others? And yeah, pregnant with a minor. Yeah, sure.
Okay. You're referring to who when you say they?
Kayla is that.
Okay. You don't remember the night that Desiree found out she was pregnant?
Objection relevant.
It goes
Sustained.
directly to what she's testifying to.
Sustained.
Do you not remember telling Desiree and Kayla that you thought you were pregnant?
No,
You don't remember Kayla and Desiree encouraging you to take a pregnancy test so you know one way or the other?
Kayla made me take a pregnancy test. Yes.
Okay, and you weren't pregnant, right?
No,
When you left yourself, when you left San Antonio yourself, you went by way of the Greyhound bus, right?
correct,
And your father took you,
correct,
and you didn't tell your father that you didn't want to go to Dallas, right?
So after this crime, her dad takes her to Dallas. Isn't that aiding a criminal? How is this not? But I'm not a fan of the consciousness of guilt, but if anything should be, then this is it.
no,
And when you went up to Dallas, you stayed with Kayla and Desiree, right?
correct.
And you called Kayla and Desiree and asked if you could stay there, correct?
I only stayed at Desiree's one night.
Okay, you stayed at Desiree's parents' house, right?
Correct.
They had a barbecue, right?
No, we didn't.
They didn't offer you barbecue from a previous occasion?
No, I didn't eat.
Yeah, maybe she was friends with Laura Owen.
While you were in Dallas, you were
Hi,
working as a
Angela.
stripper
Good to
there
have you
too,
here.
right?
They made me, yes.
We are on verdict watch, and while we wait, we are checking interesting things from the trial as cocaine stripper girls, the cross-examination of cocaine stripper girl. Ooh, I haven't sent MG Law an invite. If you want to, if you have the time. Dun dun dun. Now he has one. If he has the time.
And in order to dance in the Dallas strip club scene, you have to register your fingerprints and show your driver's license to an authority figure, to the county, right?
No, sir.
Okay, you never went to the county to get your fingerprints taken?
Yes, but I didn't have to do that at the strip club.
Right, but you did it for your work at the strip club, right?
No, sir.
Okay, why did you go get your fingerprints taken in Dallas County?
Because they didn't ask for that.
I thought you just said that you did get your fingerprints taken.
For my ID.
Okay, well, you gave them your ID, right?
Correct,
And they photocopied it?
correct,
Okay. And that was in order to get an ID for the strip clubs, right?
correct,
To verify that you were old enough to dance, right?
correct.
Okay. That would have been obviously before you say that your bag and all of your identifiers were stolen, correct?
Correct.
When you were interviewed by the detective, you indicated to the detective that there might have been some problem in your family with you dating an African-American man. Do you remember that?
Objection, relevance, Your Honor.
Sustained,
It goes to bias here.
sustained.
Please note my exception.
Motion to disregard, Your Honor, or instruct the jury to disregard.
All right, you didn't disregard the last words from counsel. Does everyone understand? Thank you.
You asked the detective if he could put money on your books so you could call your mother. Do you remember that?
He asked me if there was anything he wanted me to tell my mother, or he wanted him to tell my mother. And he asked me, should she put money on your books? I said, yeah, that's fine.
Okay, so he was going to facilitate her putting money on. That's what that was about?
Yes, he said it.
Okay. Do you remember the day that you pled guilty to tampering with evidence in front of Judge Contreras?
Correct.
And you were asked questions by the prosecution related to this offense because they knew that it would probably be some time before you would have to testify in the case, right?
Correct.
And they wanted to, I believe, get a baseline of what your testimony would be at trial. You remember that?
So,
And you were asked about the intent to rob, whether or not there was an intent to rob associated with this case. Do you remember that?
correct.
And you told the judge and the prosecutor, I guess so.
After seeing it, yes.
Okay, but did in your response to the question about whether there was an intent to rob, you said, I guess so, right?
Because it happened, I said, I guess so.
I'm just asking you, is that what you said in response to the question about whether there was an intent to rob? I guess so.
Correct, that was what I said.
And you don't remember how many gunshots were fired, right? At that hearing where you were testifying in front of Judge Contreras, you indicated that you barely knew Jeremiah, right?
When he was in school,
But you did attend school with him, right?
correct.
So you had known him for a long time,
I knew of him,
okay? But you had interacted with him before.
not like that.
Okay, I mean, when you say not like that, what you're saying is you hadn't previously been driving around town with guns and drugs in a car, right?
No,
But you've seen him in school, you've talked to him on multiple occasions, he's been to parties that you've attended as well.
I only saw him and hung out with him the time that we were at the gathering and after that,
Well, you knew that Jeremiah sold marijuana, right?
yes,
You knew that Jeremiah carried a weapon, right?
yes.
You knew that
Yeah, she knew all of that, but no, she doesn't know him at all.
Jeremiah was a photographer himself and had his own camera, right?
Yes, it felt like
You stayed at his house, I believe you said for a couple of weeks, right?
it felt like a couple of weeks.
Well, how long was it in actual fact?
I couldn't know the time frame because we were always moving places.
Okay, so you just can't commit to how long you were there.
No, but it felt like a long time.
But then it was more than one night for sure.
Yes,
Okay, when you say a couple of weeks, is that an estimate?
yes.
Have a moment to get the screen set.
Yeah, that was cross-examination. It kind of ended with a dud, but all in all, I believe they showed that she is not to be trusted. Again, my theory of this case is that she, for some reason, probably because he did something bad with her when she was in high school, so she wanted to set him up for something. She might not have expected the outcome, but I believe everything that happened in this case is because of her. He didn't communicate with anybody else but her to get there in the car. We don't know what happened between he got in the car and when he was either thrown out or got out of the car. There's a gap there. We don't know what happened. Did she tell her 3 male friends that beat him up? He did this and this and this. Maybe. I think that is a stronger case than what the prosecution has brought forward. And so I can't believe they chose to charge. They chose to not. Why are they going with her as with a plea deal? There were 2 others who could testify. So, yeah, for me, the evidence points more. Now, I don't know who actually pulled the gun and pulled the trigger. I have no idea. But everything else, that's her, in my opinion. And after trial, she is probably within a few months walking free.
Ms. Reyes, I want to show you what has been entered into evidence as State's Exhibit number 126. This item that I'm pointing at, do you recognize what it is and who it belonged to?
Slides.
And who did those slides belong to?
Taymor.
Okay. Now I want to talk to you about your interview with Detective Juarez back on September 5th of 2017. During that interview, did you inform Detective Juarez that you had told Mark Saldivar that you would be with at least 2 friends?
Yes.
Okay, and
not a single thing that corroborates it.
just going back to when you told Mark Saldivar that you would be with 2 friends, why did you say that?
Because I wasn't going to come over and we were going to be
Okay. And when you showed up, you were with 3 friends. How did that 3rd person get into the picture?
Then like we started to want to go.
Okay. Can you please describe to the jury the relationship between the defendant and Jalen Bell? Were they friends with each other?
Best friends.
Okay. Did you observe them staying together?
Yes.
And would you observe them together frequently?
All the time.
And, okay. Now, during your interview with Detective Juarez, did you inform Detective Juarez that the defendant was specifically looking for a photographer for a photo shoot?
Correct.
Yeah, but there is 0 actual evidence of that communication.
And during your interview with Detective Juarez, did you inform Detective Juarez that prior to what happened at the stoplight on McCullough, you had no knowledge of the defendant's intentions to rob Mark Saldivar?
Yes, ma'am.
Okay. In your statement to Detective Juarez, did you tell Detective Juarez that the defendant only told you that it was going to be a photo shoot?
Yes, ma'am.
Okay. In your statement to Detective Juarez, did you tell Detective Juarez that the defendant told Mark, "Give me all your shit"?
Yes, ma'am.
In that interview, did you tell Detective Juarez that Mark didn't want to give up his belongings?
Yes.
In that interview, did you tell Detective Juarez that they took Mark's backpack away from him?
Yes.
And when you say they, who do you mean?
Taymor.
Does that include anybody else? Okay. In your interview with Detective Juarez, you stated that they opened Mark Saldivar's backpack. Is that correct? When you say they, who are you referring to? Does that include anyone else? And in your interview with Detective Juarez, did you tell Detective Juarez that they beat Mark Saldivar?
Yes.
And when you say they, who do you mean? Okay. In your interview with Detective Juarez, did you tell Detective Juarez that they threw Mark Saldivar out of the motor vehicle?
Yes.
And when you say they, who are you referring to there? Okay. Now, in your interview with Detective Juarez asked you if Mark Saldivar was in possession of any weapons. Is that correct?
Yes.
What did you tell him when you had the interview with him?
No, he didn't like a boy that don't have one.
Okay. And in your interview with Detective Juarez, you further stated that you didn't believe that the defendant was acting in self-defense. Isn't that correct?
Objection, Your Honor, calls for ultimate opinion on a legal.
He's opened the door, Your Honor.
All right, that will be sustained as to entering the province of the jury.
And I'd ask the jury to disregard the question and the answer.
All right, ladies and gentlemen, you did.
For the first 3 days of this trial, the prosecution went almost overboard in asking questions they knew they couldn't ask of certain witnesses. Hence, 38 sidebars and 19 motion to dismiss, because they did it over and over and over again.
To disregard that last question and the answer.
Motion for mistrial.
Denied.
Now, I want to go back to the album cover and your role in the album cover, okay? When we're talking about you being in lingerie, whose idea was that?
Taymor's.
And in your interview with Detective Juarez, isn't it true you told Detective Juarez that the defendant, Taymor McIntyre, is the one that made you agree to wear lingerie?
Yes.
Okay. Now, when you spoke to Detective Juarez, isn't it true that you told him that the defendant was the only person that you saw with a gun on that day?
Yes.
And isn't it true that in that interview with Detective Juarez, you also informed him that the defendant was wearing a white shirt during the offense?
Yes.
And during that interview, you further stated to Detective Juarez that you observed the defendant shoot the guy on the hood of your motor
Objection
vehicle.
to leading, Your Honor.
Sustained.
In your interview with Detective Juarez, what did you tell him about who shot the person that was on the hood of your motor vehicle?
I said Taymor did it.
Her first statement was that she did it. And I mean, besides people putting her in the front driver's seat, well, we don't know how many guns there were. Maybe she fired as well.
During your interview with Detective Juarez, what did you tell him about Jeremiah Rodriguez and what he would sell?
And he sold marijuana.
And
now, for some odd reason, she starts to cry. On these questions, she's been asked a horde of different questions and even looked at the crime scene photo. And now she starts crying.
you further informed Detective Juarez that you knew that Jeremiah usually carried firearms, correct?
Yes.
Okay. During your interview with Detective Juarez, you also informed him that you, the defendant, and Jalen Bell were staying at Jeremiah Rodriguez's home for at least 1 week prior to the offense, correct?
Objection leading, Your Honor.
Sustained.
Instruct the jury to disregard the question.
Ladies and gentlemen, disregard the question.
Motion for mistrial.
Denied.
when you spoke with Detective Juarez during your interview, who did you tell him? What did you tell Detective Juarez about where you were staying with the defendant Taymor McIntyre and Jalen Bell?
Jeremiah's.
Okay. And when you were answering Mr. Hunter's questions, you kind of further expounded that you couldn't pinpoint an exact time frame. Is that correct?
Mhm.
But you're sure that you were there for some time, right? Okay. Now, in your interview with Detective Juarez, when you were asked who had the backpack when you were at the Mexican restaurant, do you recall who you told him had the backpack?
Yes,
Who is that?
Taylor.
And when Detective Juarez asked you about the camera that Mark Saldivar had, do you recall telling Detective Juarez what color that camera was?
Objection leading.
Overruled.
What color was the camera?
White.
And is that what you told Detective Juarez in your interview?
Yes.
All right. Now, Mr. Hunter asked you a question about whether you saw the camera when Mark got into the vehicle. Do you recall that?
Yes.
Do you recall the exact moment that you saw the camera? Okay. After the offense, when you all were at the Mexican restaurant, had you seen the
Objection
camera?
asked and answered and leading, Your Honor.
Overruled.
You can answer the question.
Yes.
So you saw the camera at the Mexican restaurant?
No.
Okay. Did you see the camera when y'all were at Jeremiah's house?
Objection asked and answered, Your Honor.
Overruled.
You can answer.
Yes.
Okay. And when you were at Jeremiah's house, who had the camera at Jeremiah's house?
All the boys.
When you say all the boys, who is that?
Jalen, Jeremiah, Taymor.
Okay. Now, back to the Mexican restaurant. What did you observe Jalen Bell doing with Mark's wallet at the Mexican restaurant?
He was tossing all his stuff out.
And isn't that what you told Detective Juarez when you had your interview with him? All right. In your interview with Detective Juarez, you informed Detective Juarez that you, the defendant, and Jalen Bell got a ride from Starbucks to go meet back at Jeremiah Rodriguez's home.
Objection leading asked and answered.
The objection to leading will be sustained.
Okay. What did you tell Detective Juarez about where you went with the defendant and Jalen Bell after leaving the Mexican restaurant?
And so then
Objection hearsay.
Overruled.
I told him that we went to the Starbucks next door. And Taymor was on my phone, and then a woman came and picked us up.
Now, I want to turn to you about, or talk to you about the defense counsel's line of questioning regarding whether you thought the victim, Mark Anthony Saldivar, had intentions of having sex with you. We saw the video published to the jury, but is this something that was suggested to you by the defendant?
No.
Okay. After the defendant and Jalen Bell went through the bag, what did they say to Mark regarding the items that they saw in the bag?
Taymor said, what do you think that you were going to do? What do you think you were going to do?
Okay. And on the statement that was played for the jury, you said once you were told the contents of the bag, you were shocked and didn't know what to think. Isn't that correct?
Correct.
All right. But in talking to Detective Juarez, you were kind of guessing as to what Mark's intentions were. Is that fair to say?
Correct.
Okay. And you were kind of just stereotyping him in a stereotypical male way. Is that
I'm going
correct?
to object, Your Honor. This is leading, asked and answered, and it's functionally testifying from the prosecution.
With regards to leading, the objection will be sustained.
Motion to instruct the jury disregard the statement of the prosecutor.
All right, ladies and gentlemen, you're to disregard the last question from the state.
Motion for Ms. Trump.
Denied.
When you met with Detective Juarez and gave your interview, isn't it true that back on that day in September of 2017, you told him back then that the defendant was threatening to kill you? Okay. And the detective in your interview told you that he was listing you as a suspect in the capital murder, correct?
Objection hearsay.
That will be sustained.
Lou asked, the jury instruction saying mere presence isn't enough to convict should help him. So just proving he was in the car isn't enough. Correct. Because they don't know when he was in the car. All they have is this witness testimony that Mr. McIntyre, was in the car doing all the things. They can't put a gun in his hand. There is no anything. And not only this, the jury can't even take her word for it. It has to be corroborated with independent evidence. So even if they would believe her, that is as well not enough for a conviction in Texas. Because she's a snitch. She took a plea deal. So it needs corroborating evidence. Now, the prosecution claims they have it through a grainy video and stuff. Is it enough? Juries can find it. I've seen worse cases get a guilty verdict. Much worse cases. So I don't know what's going to happen. And for the record, Mr. McIntyre is already serving 55 years for another murder. Not connected to this one, a separate one. But I've been asked by people to look into that case because they believe he was railroaded. Everybody pointed at him, more or less in the same way as here. Yeah, as Lou says, he wasn't the shooter in that one either. So I will try to find out about that case, so I can make
Did
you
the
an
detective tell you
informed
anything
opinion.
about what could possibly happen to you if you spoke with him?
Yes,
Okay, and did that include being charged in the offense?
yes,
And you still decided to talk with him, correct?
yes.
And when you spoke with Detective Juarez, did you have any plea agreement in place?
No,
Did Detective Juarez promise you anything in exchange for your interview?
no.
Why is she
At any
crying
point?
about
well,
these
you know what?
questions?
Now I want to turn to the day that you entered your plea agreement. Do you recall that?
Yes, ma'am.
All right. And you gave testimony on that day, is that correct?
Yes, ma'am.
All right. And so on the day that you gave testimony, isn't it true that you testified that you had met Taymor McIntyre at the gathering at Isaac Ibarra's house?
Correct.
Okay. And in that testimony, didn't you further state that you had been with Taymor McIntyre from the beginning of April?
Yes.
Okay. In the testimony that you provided on that day, isn't it true that you stated you and Mark followed each other on Instagram and Taymor wanted a photographer for his album cover?
Yes, ma'am.
Again, besides her contacting him, there is no evidence that Taymor ever said this.
In the testimony that you provided, isn't it true that you stated that Taymor told you what kind of plans he had for the album cover, and that included Taymor McIntyre wanting you in lingerie and wearing a mask with weed and guns? In the testimony that you provided, isn't it true that you stated that you, the defendant, and Jalen Bell were staying at Jeremiah's house?
Yes, ma'am.
And you stated the people that were staying at Jeremiah's house was Taymor, Jalen, Desiree, Jeremiah, and Jeremiah's family.
Yes, ma'am.
All right.
Yeah, I mean, as Lou says, the photo shoot was obviously for the stripper. I mean, it has not been presented anywhere that this victim had that album cover or anything. It seems like his Instagram was all about getting girls undressed. Nothing about any album covers or anything have been presented by the court. Oh, but he took other kinds of photos. So all we know is on Instagram he had pictures of nude girls. Allegedly, some of them minors.
Okay, and the testimony that you provided, you stated that you were the driver of that black Kia Forte, correct?
Yes, ma'am.
And in the testimony that you provided on that day, you further stated that when you picked up Mark Saldivar, he had a camera and a backpack, correct?
Yes, ma'am.
I'm going to object to answer to cumulative. I also don't think it's a proper impeachment. They can't offer a prior consistent statement if we didn't attack that statement for fabrication.
Judge,
Objection is overruled.
thank you. Now, in the testimony that you provided on the day that you entered your plea agreement, isn't it true that you testified that Taymor McIntyre was sitting in the front passenger seat of your motor vehicle?
Yes,
And on that day, you further stated Jeremiah was sitting behind you, correct?
correct.
And you also stated on that day that Jalen Bell was in the middle seat, correct?
Yes,
And that the victim, Mark Saldivar, was sitting directly behind Taymor McIntyre, correct?
yes,
All right. On the day that you entered your plea agreement, you further testified that when you all were at the stoplight, Taymor bought out the gun and pointed it at Mark, correct?
correct.
You further stated on that day that when Mark didn't want to give up his bag, immediately Taymor started hitting him with the gun.
Correct.
On the day that you entered your plea agreement and provided testimony, isn't it true that you testified that Taymor used and pulled out the gun and stated to Mark, "Give me your backpack"?
Correct.
And the testimony that you provided on the day that you entered your plea agreement, isn't it true that you stated that you were telling Jalen, Taymor, and Jeremiah to just let Mark go?
Yes,
In your previous testimony, you testified that Jalen pushed Mark out of the car, correct?
correct.
All right. In your previous testimony, you testified that once Mark was pushed out of the car, he jumped on the hood of your car, is that correct?
Correct.
And in your previous testimony, you testified that you pulled over into the Chick-fil-A.
Yes, ma'am.
In your previous testimony,
Sorry. Before we continue, YouTube allows me to gift 10 free memberships per month. I used 5 of them about a week ago, and now 5 more. So, Matthew Felty, Tremory Crandall, DK Cripple, Mimi, and CE was gifted memberships. Now you have access to all my members-only content. You have access to your own emojis here on the channel. And if you go to my channel page on YouTube, you will have a link to my Discord. So that is what was gifted as of now. If anybody is thinking about it, hey, let's sponsor this guy. He seems cool, or old, or starving. $3 a month for all of that. All right. That was the grifting thing of this stream.
testimony on the date that you entered your plea, you testified that Mark was on the hood of the car because his stuff was still inside the vehicle, correct?
Yes, ma'am.
And in your previous testimony, you did testify that Mark Saldivar kicked in the windshield, and that's when Taymor got out of the car and shot him, correct?
Correct.
When asked on that day how Taymor shot Mark Saldivar, you testified that the defendant, Taymor McIntyre, opened the door and leaned halfway out and halfway in and shot Mark Saldivar, correct?
I'm gonna object to ask and answer. If we're gonna go through everything in the transcript, we could just offer.
You can make your legal objection. The court will hear the legal objections and make a ruling. So what is your objection?
If I could have a running objection, since we're going through.
What is your
everyone,
objection?
That all of this is cumulative and asked and answer the previous, and much of it is not proper rehabilitation on impeachment by prior consistent statement.
All right, your
And
objection.
if I may respond briefly, Your Honor.
Yes.
They have attacked this witness's credibility. They have alleged that she is testifying under an improper influence or motive. And so under Rule 801 E1B, I am allowed to explore this line of questioning with her.
Objection is overruled.
And since they further stated that they have no objection to the transcript coming in at this time, the state would offer State's Exhibits 132, which is the transcript, and 133, which is her recorded video statement.
Any objection?
132, no objections, prior sworn testimony. Objections to 133, because the proper method of doing that is to.
Well, no, my question is, do you have any objection? And if you do, what's the legal objection?
That the entirety of the statement is not admissible. It contains a great deal of hearsay from another declarant not present to testify.
All right, and which exhibit is that, please? The one that the defense is objecting to?
That would be 133, Your Honor.
All right. Defense states that there's hearsay in 133. Any response?
If you'd like the detective's questions for DACT, I can do that over a break and offer.
All right. With regards to State's Exhibit number 133, defense's objection will be sustained. And what is the other exhibit number, please?
132, Your Honor.
And defense, you have no objection to 132?
Okay.
All right. State's Exhibit number 132 is admitted without objection.
Yeah, as Erica Thorpe says, she is no nonsense, which I appreciate. I agree. I might not agree with all of her rulings in this trial, but everybody, defense, prosecution, they have been here before in other trials, other hearings, and everything. Everybody knows this. So she is very consistent in what she does. Do I agree with her all the time? No. But that's just the way it is. Matthew asked, what is the jury size? This is capital murder in Texas. It's 12 plus 12. I believe it is. It's the maximum amount of jurors and alternates.
Ms. Reyes, at any point between the offense date until today, have you ever named anyone other than Taymor McIntyre as the shooter and murderer of Mark Saldivar?
No,
How the fuck does that prove anything? From when you signed the plea agreement until now, have you named anybody else? Of course she hasn't. If she had, you would have charged her with perjury.
Oscillator.
Defense?
Briefly, Your Honor.
Yes.
Did you ever tell anybody that he has a gun right before Taymor shot him?
Objection, that's been asked and answered.
Overruled.
Oh, she was overruled, sorry. Have you ever told anybody have you ever told anybody that you were yelling he has a gun right
No.
before Taymor shot him?
no,
You said that Taymor wanted this photo shoot for his album cover, right?
correct,
But you told Desiree in Dallas that it was for the promotion of your career as a stripper, right?
no,
And just to be clear, you've testified throughout this process that Jalen had the backpack and was going through it, and Jalen had the wallet, right?
correct. Taymor had the backpack as well.
And you told the detective that Jalen threw the phone at him.
That's what he said.
Okay, but that's not how you told it to the detective, right?
I said, that's what Jalen said.
Okay, that's.
sorry, what was that?
3619.
3619.
Oh, sorry, Thomas, can you?
Oh.
I'm sorry. Did you say that that's what Jalen told you, is that it was thrown out of the car?
Yes.
Okay.
Hey, Dolly's here. You would like this girl, Dolly. She's a
You told the
cocaine stripper.
detective that you had no plan to rob Mr. Saldivar that day when you got in the car to go pick him up, right?
Correct.
And your judgment of what Taymor and the other men in the car did is then based on their actions, not their words, right? To you.
Correct.
Nobody ever said, hey, Joanna, we're going to go rob this guy today, right?
No,
Okay. That wasn't something that you expected to happen when you got there, right?
no,
These men reacted to Mark when he got in the car and this thing escalated and then it happened, right?
it happened at the stoplight.
At the stoplight.
Yes.
Okay. So when you told the detective you believed that this was a robbery, you're basing it off what you saw these men do at that stoplight.
Correct.
And so the very beginning of our questioning yesterday, you and I were talking about the fact that Mark had contacted you previously on Instagram. You blocked him, and then you made contact with him again, right? And that you were discussing this photo shoot with Mark, right?
Correct.
And in that conversation, you weren't telling Mark that it was about the album cover, was it?
I don't remember texting him much. Taymor would text him as well.
Okay, but you definitely had conversations with him, right?
Yes,
And all of the conversations were on your phone, right?
yes.
So let me ask you this. Did you give the police your phone?
No, because Caleb broke it.
Okay. So you didn't have a phone to provide the police?
No,
Did you have the broken phone to provide the police?
no,
Did you give the police your account information to log into Instagram?
yes,
Okay. Did you give the police account information to log into Snapchat?
yes,
Okay. So you don't know what happened to those things.
no,
Were you given any Instagram messages or Snapchat messages to review in preparation of your testimony?
no.
Yeah, that's true. Sal is not in. Well, she won't be interested in Sal because her preference in males are, let's just say, she claims she believes Taymor was 18, despite being her height, half her weight, scrawny 15-year-old when they met. I'm very glad she is not a teacher.
Ask the witness.
No further questions.
Is this witness excused or subject to recall?
Used by the state, Your Honor.
Subject to recall.
Yeah, this recall, I was looking forward to it because the defense, all up until the night before the defense case in chief, they had her ex-boyfriend as a witness. But the night before, he lawyered up and told them he was going to plead the fifth. So all the impeachment they did with his information in mind, gone. So I believe their plan was to call him and then recall her. Instead, they ended up with no case in chief. And that's so sad. Now, this is more or less the only real highlight of this trial. So I'm going to actually watch, I think she had a morning docket, I believe. Let's see here. No, that's not it. That's not it. Was it that one? No, not that one. Not that one. Not that one. Damn, I'm looking for. She had a morning docket. There she is. So let's check out morning docket instead. While we wait. While we wait.
I love strawberries, and their strawberry festival is always great.
Strawberry wine.
Oh, now see, I don't drink, but
You can make an exception.
Yeah.
One more time, come on.
well, I tell you what, if I were to drink strawberry wine, Deputy Lord, we would have to sing the song "Strawberry Wine." I love that song. And you know what? Thank you for saying that, because the song I had in my head over and over was Neil Diamond's "Hello." So now "Strawberry Wine" is in there.
That's what I need.
And yes, we are still on verdict watch. I believe she will end today's deliberations at 4:35 p.m. Texas time, which is half an hour or an hour away. So we will keep checking out Judge Boyd in her natural element in this morning docket. Yeah, this is something I'm so impressed, because usually if a judge are in a trial, they have nothing else on their docket. Judge Boyd, even in some of the breaks in the trial where the jury went away to for not for lunch but for afternoon break, she did cases. And I'm so impressed by her work ethics. Hi, Erica. Good to see you.
You can have digital circulating.
Oh, that's always nice.
I'm going to up there instead.
Well, I'm about to talk to Cornelius when I see him, because Florida was playing a basketball game, but also acting as though they had all the time in the world. I know his heart was racing.
They will.
Oh, they did by 2 points,
Oh, wow.
but they were down by 12. And I know Houston is thinking, we had them and we let them go. Okay. All right, I'm going to call the docket. When I call the docket, you need to stand and let me know you're here. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. Alexander Rodriguez, custody. Tyler Millette. Tyler Pierce Millette. Brandon Banks, custody. Valdemaro Joseph Chapa. Emilio Rangel. Dustin Newkirk, Amanda Hernandez, Nufo Esquivel, Robert Thompson. Custody, David Richard Graham. David Richard Graham. Adolph Mendoza. Thank you. Kenneth Howie, Eugene Navarro, custody. Jesse Garcia. Thank you. Aldo Sandoval, custody. Heather Pippin. Rodney Garza. Selena Allen, custody. Mark Ivy, I think federal custody. Alan Minares Perez, yes. Juan Clara, custody. Willie Cunningham, thank you. Gregory Jennings. Here you are. Thank you. And could I see the file on Willie Cunningham, please? Robert Thompson, custody. Adrian Morales. Kevin Deleuze. Kevin Kenneth Deleuze. Jeffrey Kesey. Daniel Hernandez. Joshua Cannon, custody. Ezekiel Neely. Thank you. Richard Baker, custody. Juan Carlos Castaneda. Dustin Newkirk. John Hayes, custody. Is there anyone who came in late or your name was not called? All right, in the back. John Paul what? Who's your attorney?
I'm sorry, man, all you're subpoenaed.
All right, see, this is what I'm talking about. And if I'm wrong for saying this, please let me know. But statistically speaking, when I was a defense attorney, you know, even if your client was a male, you know who you gave the reset forms to and the information to? You gave it to the sister, the mom, or the wife. Men, come on. Thank you for letting us know what's going on with him. I appreciate that. So do you know who subpoenaed you? All right, so state, if you all can check and see if you're the person who subpoenaed John Paul Rodriguez. I don't know which case he would be here for. Thank you, miss. All right. Ah, all right. And why isn't that on the docket? Page 10? All right, thank you. And who are the people who are coming in? Ah, all right, thank you. And then there's somebody here who says they were subpoenaed. A John Paul Rodriguez. All right, everyone, these are the rules. Attorneys, do you know the rules? Do I need to repeat the rules? All right, thank you. So everyone in the gallery, if you do not see your attorney here, you have the court's permission to walk outside and call them, because we're starting the jury trial up at 1:30, which means that we're recessing here at 11:30. So if you don't see your attorney, step outside and call them. Otherwise, you're going to be called back on another day. All right, thank you. Everyone, please confer. And Willie Cunningham, can you come forward, please? Hello. Hi. Hi. You always dress appropriately for court. I really do appreciate that. So last time your attorney was in trial, and this time the court is currently in trial. So of course we can't try two cases at the same time. Are you employed?
No, ma'am, not currently.
Okay. Well, this is what I'm going to do. I'm going to reset you for a Monday. And on that day, you don't have to come in. You can appear by Zoom. And then, because usually we start jury selection on Tuesday. So that way you won't have to come down unnecessarily. All right?
Yes, ma'am.
All right. So how long you expect this trial to last?
Oh, Judge,
3 days,
3 days?
3 to 4.
All right. Is Norma there?
No.
All right. So I'm going to give you all a jury trial date.
Okay.
And who will be trying? Yes. What is your week? Do you know when your family violence week is?
This is last week, but come up next week.
No. So technically this week is family violence week. So let me see. Trial division. You know what I'm going to do? You think in 3 days?
3 to 4.
All right. So what I'm going to do, and you'll need to be here. I'm sorry about that. I can set you for the week of April 21st. Are you available that week, counsel?
Yes, Judge. I've got a setting in federal court that morning.
No.
But
I'll just set you on the 22nd because that would be jury selection.
Oh, for the 22nd.
So you'll need to be
Yes, Judge.
here on the 22nd, okay?
Just first and
22nd. Okay. So I'm going to put you on April 22nd.
Okay.
Could I have a reset form? All right.
All right, thank you.
All right. Thank you so much. Once you sign the reset form, you're excused.
All right, I just got things that Judge Gull in the Delphi trial, orders that was sealed. It's about 100 pages of orders that she ordered to be sealed before trial and during trial that are now unsealed. Most of them are for expenditures for the defense. And I skimmed through them while we were here. I understand why some of them were sealed. But one of them is... This is just Judge Gull protecting herself. One of these is the defense wanted a clinical psychologist talking about false confessions. She denied that. Yeah, that will be a separate stream. Let's go back to this.
Mr. Kesey is,
Yes.
Mr. Kesey is here to discuss his travel
Yes.
request.
All right, let's bring it up.
Ms. Jones is not here yet. Did you want to just move forward for it?
Yes. Let's do the following. Kesey.
That's a good word.
It says the court will not authorize expenditure of $550 per hour for a confessions expert. That's the clinical psychologist there to talk about the unreliability of confessions under distress. Judge Gull denied that. Oh, you cunt. If you're offended by words, you are on the absolute wrong channel. You know what? This is part of another unsealed order. I will pause here, share this, and I will temporarily remove that so I can cut this out as a separate video. And I will start with Swoop. All right, folks, here is one of the now unsealed orders from Judge Gull. This is over 100 pages combined. This one specifically I want to talk about. This one. And yes, my swoop is the Norwegian fire farting dragon. You can't sneak up on that from behind. All right, let's go through this one at least. Confidential and sealed. The court, having taken defendant's verified ex parte motion for hearing on funding for expert services, filed February 24th, 2024, under advisement, and having been duly advised, now grants in parts and denies in part defendant's motion. The court will authorize a $900 fee for a 2-hour visit with Dr. Polly G. Westcott, clinical psychologist. Counsel had requested the court authorize additional authorization of $450 per hour for Dr. Westcott to review medical records, videos, and interviews. That unsupported request is denied as an unreasonable expenditure of county funds. So she allowed them to go there, visit her for 2 hours, but denied everything else that would have made her a possible expert witness. The court will authorize services of private investigator Brian Alvey at the hourly rate of $40. However, for the court to approve any invoice, the investigator must provide the following information: date service is provided, type of service provided, what the service entails, and the amount of time necessary for the service. The court has previously rejected generic invoices as unsupported and will continue that practice. Can you imagine why they don't want to tell Judge Gull what their investigator was investigating? For me, that is absolutely clear, because in my opinion, she would hand it over to the prosecution in a heartbeat. They are investigating that thing. Of course, they have to be generic, because otherwise she would tell the prosecution, ruining the defense case for the defense. The court will authorize a payment of $3,712 to Dan Smith, digital forensic expert. The court will not authorize additional expenditures for Dan Smith at his hourly rate of $165 as unsupported. I don't know exactly what this means. The court will authorize payment of $2,500 to Dr. Eric Warren for tool mark analysis. The court will not authorize additional expenditures for Dr. Warren at his hourly rate of $300 as unsupported. I would assume that would be regarding both of these people getting there to testify. So she more or less, they can do some investigation, but I will not support them testifying. This is my interpretation. I might be wrong. But knowing what I know about Judge Gull and her conduct in the Delphi case, I stand by my interpretation. The court has previously addressed the invoices of Matthew Hoffman, characterized as an in-office assistant to Rossi and Baldwin. Said invoices have been woefully inadequate and unsupported. The court will not authorize additional expenditures of $15 per hour for Mr. Hoffman for that reason. Yeah, you can't have anybody helping you. That's about it. The court will not authorize additional expenditures to Max Baker, in-office assistant of Rossi. Again, you are not allowed to have help. The court may authorize additional expenditure for paralegal services upon presentation of proper invoices. I don't think now I haven't seen the invoices. It might be that they weren't good enough. I highly doubt it. I highly doubt it. It's just Judge Gull who does not want to pay for Mr. Allen to have a proper defense. The court will not authorize additional expenditures for a consulting pathologist with an hourly rate of $400 to $800 as unsupported. Consulting pathologist. That would be a person checking out the crime scene and testifying about the crime scene. No, Judge Gull believes that would be unsupported. The court will not authorize expenditure of $550 per hour for a quote-unquote confession expert as unsupported. This, folks, is Judge Gull not allowing Richard Allen a proper defense. And this is just one. I believe I read from 2 pages out of 100 pages which Judge Gull sealed and have had sealed all this time. These are unsealed via the appellate attorneys. Not because now this is out of Judge Gull's hands. Now we are getting more information, folks. Finally, we are getting more information. And just by reading from this order from her to seal, she really, really did not want Mr. Allen to put up a proper defense. She denied it. And remember, folks, some of these expert witnesses did turn up to testify. And why was that? Because we fundraised. My channel had a fundraising for Mr. Allen to have expert testimony in the trial. I think somewhere over $2,000, $2,500 was made to that fundraiser through my channel. Hopefully he got at least a couple of hours of testimony from that. But this should have been paid by the state. But Judge Gull is Judge Gull, and Judge Gull does not like people putting up a defense. And now, swoop. I will cut out that for a separate video. Okay? Let's see here. That was around 2.5 hours in to this stream, which I will not remember. I will find it eventually. CCNSD. How is she still a sitting judge? She's elected. She's up for re-election in Indiana in 2026, I believe. So if you are in Indiana and have the ability to vote Judge Gull out, for fuck's sake, do it. Do it. All right. Back to a good judge. Let's keep listening to this.
Jeff. All right, Jeffrey Kesey.
Yes.
Oh, come on. Okay. Hello.
Yes.
All right. Thank you for dressing appropriately for court. So you want to travel?
Yes, ma'am.
All right. And where do you want to go and why?
Back home. It's my 21st wedding anniversary, and we're going back to our first wedding anniversary, which is in Oklahoma, and go to the Arts Fest. Will be at our first anniversary.
Okay. All right. And Miss Abrams,
Yes, Judge.
how has he been doing on probation?
No concerns, Judge. Everything's been going good.
And you all are still doing field visits, correct?
Yes, ma'am.
Okay. All right, I'll allow you to travel. And Ms. Abrams, he'll need to do a UA upon return.
Yes, Judge.
All right, is there anything else you need?
No, ma'am.
All right, happy anniversary.
Thank you.
25, I think 21 years in Hollywood. How many years is that? 90 for anniversary in Hollywood time?
Oh.
21 years anniversary is 90 years.
Next time 7, like a dog's age.
Oh, wow.
Okay. All right. Have a good one.
Thank you, ma'am.
You're welcome.
So, I'll let y'all.
Morning. Hi. And they're crying because they want to play or they're tired. All right, are you already on Ms. Frias?
Yes, I believe so, Your Honor.
Oh, can I see the file on Frias, please?
I see that Slidy Pie over at Rumble says thinks we'll have a verdict today. Well, I am checking Judge Boyd's YouTube page and still nothing that says anything close to reaching a verdict. She has no information.
All right. So, counsel, did you receive the report from felony drug court?
I had not, Your Honor. I just had received word that there may have been a positive, but
Well, I think, and we'll go on the record in just a moment.
Okay.
But I think that, could you hand me that printout, please? When it comes. Thank you.
thank you, Your Honor.
Mhm. All right, so we're going to go on the record in 2024 CR 011808, State versus Teresa Frias. Could I have parties announced for the record for the state?
For the defense, Renee Munoz, Your Honor.
And are you Ms. Frias? All right, so the court received the report back from felony drug court. Counsel, I think that felony drug court will be appropriate for her.
I agree with Your Honor with that assessment, to see if she can be evaluated and meets criteria for that. I know that my clients have experienced trauma in the not so distant past, in terms of being a victim on an aggravated assault with some pretty substantial gunshot wounds, and She's been out in the community, and I explained the situation with the positives, and that it's addiction is sometimes steps you have to work through, but that the court would likely be recommending that felony drug court. And I was telling her about the program, explaining to her, it'd be some years of probation, monitoring, and treatment as they deemed necessary. So we're perfectly fine if the court wants to make that referral, Judge. Due to some of the overcrowding issues at the jail, we wanted to see if she could report on outside in the community to see about the evaluations she's been making in support here as ordered. She hasn't picked up anything new.
Oh, and can I have the that printout again?
Oh, yes,
please?
Your Honor. Thank you. To address her substance use issues.
All right. So do you live by yourself or there are other people in the home?
I live with.
Hmm?
I live with.
All right. And, oh, I'm sorry. Can you raise your right hand for me? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand, state your name for the record.
Chris.
All right. Are there any minors in the home?
I have a 16-year-old.
All right. And how many children do you have total?
I have 6 total, but I just have the 6.
All right.
She
And I'm sorry?
She let me have that. Like
She's what?
with me and then with dad. So I get like 2-3 days. She'll be with him. The rest back and forth.
All right. And who is your support system?
My boyfriend
Mhm.
and my, I guess, in-law.
And so do you live with your boyfriend and in-laws? All right. And how long have you been living with them?
I say 8 months because I just got out. I don't know if it counts, but the jail time.
Okay.
I was in there for 6 months.
And I will tell you, and your counsel will tell you, I require that probation does field visits. So if you're going to be staying there, probation is going to come in and do field visits. And if they don't want probation doing field visits at their house, then you're not going to be allowed to stay there. You understand? All right. And you all recommended deferred, but neither of you all put down outside the agreement what length you are requesting. So it's
2 years. That's our understanding, Your Honor.
all right. So what I can tell you is I'm going to give you more than 2 years. The reason being is because drug court is a 2-year program. And sometimes, well, not sometimes, they have a 2-year program and the aftercare program is 6 months. Now, whether you're in that program for the full time really is dependent upon you and how you do in the program. You understand?
Yes.
All right. So the court is going to sentence you to 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors, field visits 1 time per month until further notice. There should be a referral to felony drug court. How far did you go in school?
I graduated.
All right. So what are you planning on doing with the rest of your life? What is, before all of this happened?
I was going to manage it. I love managing.
All right. Managing what?
Well, I've always worked at Wendy's. I was at Wendy's for 9 years.
All right. So that's what you want to do? All right. And you know what I always tell people, whatever your dream is, that's your dream. We need people, we need managers. If somebody comes to me and say they want to be a farmer, I'm like, yes, we need farmers. So every place where you see people working, we need those people. So I always tell everybody, no matter what your job is, sometimes we think our job is not important and, oh my gosh, what have I been doing with my life? But that job is needed. For example, people will say, oh, that person just bags the groceries at HEB, or that person's just a cashier. And I always tell them, don't say just, because we need a cashier. We need somebody to bag groceries. We need all of that. I'm still upset that they took away the full service at the gas station, but that's just me. All right. So I'm going to give you 200 hours of community.
Yeah. Here, one of these things I really, really like about Judge Boyd. If she thinks you deserve a chance, she will give you the world of opportunities until you don't deserve it anymore. But she will give you chance after chance if she believes you are deserved of chances.
Service restitution. 100 of those hours will be deemed satisfied once you complete parenting classes, and another 100 hours will be satisfied if you complete some type of trade school or higher level education. And what I can tell you, some places that you work for, even at McDonald's, they will actually pay for part of your college education or pay for your school. And if you want to really move up quickly in the system, try to go to a trade school and get something in business management or something that will make you indispensable to the company. Because you see at all of these stores where they have now self-checkout, I always tell people that's a sign. You need to pay attention to that. So can you imagine now you have about 8 self-checkouts in one general area, and they just have one person who works for the company stand there to make sure everybody's scanning things appropriately. Pretty soon, they're not even going to have that person. So that means all those cashiers' jobs are going to be eliminated. So pay attention to, as Briscoe County Junior would say, the coming things, so you can be ready for it. All right.
Definitely good advice. Thank
yes.
you, Your Honor.
All right. I'm going to ask for 90 sober meetings in 90 days.
Wow. That's
taking
lot.
consideration 2024 CR 011807. Yes, thank you. There's to be restitution, if any, and no contact with Gina Rodriguez. And there's to be no contact with Martin Alonso. And Carla, Karla Alonso. And there's also to be no contact with (214) East Mayfield. And that's 78214. Probation, is there anything else that's needed?
Okay.
Is there anything else you need from the court in order to be successful?
Definitely. If you need anything else, that's well.
Oh, no, I think we appreciate it.
All right. And did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. I know that life gets hard for people. I know that sometimes we get into relationships and we wake up and we say to ourselves, how did we get here? But if we are in relationships that are not good for us, best bet is to get out of that. With regards to drug use, let me explain.
Oh, folks,
To you.
I saw that Judge Boyd was live, and I was, oh! Yeah, she's having a Zoom meeting. She's doing work during Verdict Watch. And it just started. So, well, we were done with that case in the other. I'm going to go here instead, because this is actually live.
2024 CR 1810 and 2024 CR 1811, State versus Jason Densler. Could I have parties announced?
Jim Altersdorf for Jason Densler.
And are you Jason Densler?
Yes, Your Honor, I am.
Counsel, have you received all discovery in each of these cause numbers, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovering each cause number. And each cause number, sir, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment in each cause number?
Yes, Your Honor.
State, are you proceeding on the indictment as presented in each cause number?
We are.
And each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
And each cause number, you're charged with credit card or debit abuse with a repeat enhancement allegation. If the state is able to prove up the repeat enhancement allegation, then your range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. Did you understand by entering into these plea bargain agreements, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am, I do.
Counsel, in each cause number, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney in each of these cause numbers, and did you understand it?
Yes, Your Honor, I did.
And each cause number, according to the plea bargain agreement, the cases are to run concurrently. There to be no contacts with the complainant and restitution to the complainant. Punishment is to be assessed at 4 years in the prison, and there are no applications. Did you understand that to be the plea in each of these cause numbers?
Yes, Your Honor, I did.
Defense, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I do understand.
Counsel, are there been any such motions?
No, ma'am.
Then in cause number 2024 CR 1810, how do you plead? Guilty, not guilty, or no contest?
No contest.
And in cause number 2024 CR 1811, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Will offer states exhibit 1 with attachments.
No objections.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, I did.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. To the enhancement paragraph in each indictment, how do you plead? True or not true?
True.
Excuse me, off the record. Excuse me, off the record for a moment. Could you have Jason and come down and tell him to call the defense to come? Oh, all right. If you'll call Jason to come down, and we're back on the record. After reviewing states exhibits 1 and attachment in each cause number, the court is going to find there's sufficient evidence to find you guilty. In each cause number, the court is going to find the enhancements true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, I took him from the court, the competency court to this court, and he's a nonviolent offender. His history is of the nonviolent nature, including his enhancements. I'd ask the court to file the plea bargain.
All right, let's discuss the restitution. And cause number 2024 CR 1810. What is the?
Just for the record, this is actually live. Judge Boyd is in court at the time doing docket work. The jury is still out deliberating. So I will keep this on until she decides to go home.
Restitution amount. I saw something in the STIPS that says $6,300. I don't know if that's total or not.
That's one case, Judge.
I thought that was in the.
I've got it backwards, Judge. 2024-1811, I believe is 63, around 6,300. That would be to George Salinas.
All right, no, actually, George Salinas's, it's not the 6,300, the other complainant in the 810.
Right, on the class number ending in 11, the amount is 6,300. And that's to John Kelly Valadez. And in the cause number ending in 10.
Wait. So 11,
Yes.
you're saying that's the 6,300 to Valadez?
Yes.
Okay. And the 10?
0. It's 1,300. To George Salinas Jr.
All right, so in that case, I saw that they said there were 2 MacBooks and they were valued at $1,399 each, and there were 2. Am I reading that incorrectly?
No, you're reading that correctly. That's to the design company, which is Mr. Valdez, I believe. Is that right, sir?
That's my recollection.
Yes, sir.
So, I mean, is it $1,399 times 2?
Yes.
And so where's the $1,300 coming in?
I believe that is how much was used on the card?
That was the ATM amount, I believe, on Mr. Salinas.
Well, then I put it at $4,098.
Yes, ma'am. Yes, ma'am. That's fine.
All right, so let me do this. And cause number 2024 CR8. Sorry, 1810.
One second.
The court has previously stated it's finding you guilty. The enhancement's true. This is the run concurrent with 2024-1811. There's to be no contact with George Salinas Jr. There's to be restitution of $4,098 to George Salinas Jr. And there's to be 4 years in the prison, credit for any time served. Is there anything else with regards to that cause number?
No, Your Honor.
And then in cause number 2024 CR 1811, the court is finding you guilty. The court is finding the enhancement true. This will run concurrent with 2024 CR 1810. There's to be no contact and restitution to John Kelly Valadez in the amount of $6,300, 4 years prison, credit for any time served. Is there anything else with regards to sentencing in that cause number?
No, Your Honor.
In each of the cause numbers, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, sir.
Because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am, I do.
All right, and then they gave me 2 other cause numbers. Oh, this was just extra. Oh, thank you. All right, we can go off the record. Here's the thing. You're gonna have to make decisions in your life. Do you want to continue to steal? You know, everything that you stole, is it worth 4 years of your life?
No, ma'am.
You cannot be building your happiness off somebody else's misery. I know your counsel said these were not violent offenses, but people were still violated. Now you have somebody who perhaps because you took $6,300 out of their bank account, maybe they have payments that come out of their account, their mortgage, their utilities, and maybe all of that bounced because you stole from them. Can't do it. If you have a drug or alcohol problem and need help with that, there are plenty of places in San Antonio that are free. I'm not the judge in this court, it's Judge Murray, but when you're released from prison, if you can't find a place to get help, if you have mental health issues, if you have drug issues, if you have housing issues, if you can't find a place that can help you, you can always come back to court. If I'm here, I will pick up the phone and call to get you help. You understand?
That's great, thank you.
All right, you're welcome. Good luck to you. You're welcome. Good afternoon. All right. We have a question, and I'm going to print out an answer for you all. And I don't know if you all want to give them this answer or not, or if you all want to go ahead and release them for the day. But just 1 second. All right, state defense.
Okay. Oh. Get the names of the rooms of each one in the call box.
Now I can do that one, or either I can do, you have all the evidence because it's back there. And can I have that, the next that's printed out? Thank you. State defense.
I think just to
It's just
I
the
know they're
boilerplate
about
one.
the evidence. I think we'll all agree about that.
That second one.
That second one, Your Honor, everyone should agree. Yeah.
That one, Judge, and not this one.
Okay. All right, we're gonna go on the record. All right, the court has received the following question from the jurors. Can we get the names of the owners of each number from the call logs? Have both the state and defense had a chance to review the question?
Yes, Your Honor.
Yes, Judge.
The court suggests the following supplemental charge with reference to your inquiry. You now have before you all the testimony, exhibits, and evidence that was submitted, and you are instructed to continue your deliberations. Any objection to that being the answer?
Not from the state.
Not from the defense.
Any objection to that, to sending that answer back to the jurors?
Not from the state.
And so as agreed, I'll bring the jury in at 5. It's-
That's what I walked about, actually.
All right, because we're close.
We'll be back at 5.
All right, thank you.
And she's gone again. Hopefully she returns. Yes, we are now exactly live. So now it's a waiting game. Now it is a waiting game. Yeah, I'm not, I wonder what the question was. I wonder too, but they cut it out. Let's play some music. While I go visit the big boys' room.
juror there.
All right, for the jury.
Do we have a verdict? I don't know. Is it a new question? Is it a verdict? I don't know.
Please be seated. All right, ladies and gentlemen, I'm going to allow you to take your recess for today. The instructions I am going to give to you are the same instructions that I've been giving to you. But I cannot stress enough that you must follow these instructions. Does everyone understand? You have begun your deliberations. You are not allowed to deliberate again unless you are in the jury room and all 12 of you are in the jury room. Do you understand? You are not, it'll probably be best, don't even think about this case unless you're in the jury room and all 12 of you are there and you're deliberating. So what that means is when you return, if there are 8 of you there and we're waiting for the others to appear, you're not allowed to talk about the case or start deliberating about the case internally with yourself or with the persons who are there. Does everyone understand? You are not to do any investigation work. You're not to watch anything about this case. If you see anything about this case, you are to ignore it. You're to keep your badges visibly displayed because there are attorneys that are probably going to be walking around throughout all of San Antonio because of this is the week of fiesta, right? So if somebody starts talking to you about this case or you hear somebody talking about it, ignore it, move away. If somebody asks you any questions about this case, you're not allowed to answer. Does everyone understand? There should be no media or anyone calling you. I don't think there will be, but if somebody does, let the court know. Does everyone understand? All right, do you all have any questions before I tell you when I'm going to expect you back? All right, so all of you, all 14 of you will need to be back here on Monday. And Monday, the same number of jurors that are usually called up will be the same number that
Only
were here
14
last week.
jurors?
So you know parking
Is
is
it
going
an
to be at a
8-6
premium.
jury? Or 10-4?
So if you want, you all can come back at 9, or either you can come back at 9:30 on Monday. 9:30 or 9? 9. All right, so you'll need to be back at 9. Now the 2 alternates, you will not be in the room with them for deliberation. And everyone, when you begin to deliberate in the alternates, you will need to return your cell phones to the deputies. Does everyone understand? Anything you do not understand?
12 and 2.
All
Thank
right,
you,
we'll see
Matthew.
you back Monday at 9 a.m. If there is an issue with employment, what I can tell you is they are not allowed to dock you or penalize you for being here. If there is some issue with employment, just let us know. And I will write a letter to let them know that you're serving on a jury. All right, everyone, please rise for the jurors.
Okay. No verdict today. I'm a bit surprised. I would assume that it would be fast in either direction. But after 4 hours of deliberation,
Right, everyone,
no
please be
verdict.
seated. And, all right, thank you. All right, the jurors will be back on Monday at 9. Yeah, you all will be here. If they have any questions or there's some issues, of course, we all have your numbers and we will call you.
Sure. Thank you.
All right, is there anything else?
I have a excused Your Honor, and I will not be here on Monday.
All right, yes,
Thinking I have cleared up with my client.
all right, thank you.
Yeah, no verdict today. Nick, what do you think the jury was asking for? I was not entirely sure, but somebody else was. Let's see here. Where did that comment go? Well, I believe it was a question regarding what phone numbers connected to people. And the answer was, you have all the evidence in testimony or whatever's. So they might have been asking because did Tay-K actually contact the victim or not? But all they have is the testimony and evidence the prosecution seemed, provided. So, that, I'm a bit surprised. I'm a bit surprised that it didn't get a fast verdict. Is this good for the defense? Impossible to say. It's really, really hard to know where a jury is leaning. Very, very hard. But thank you to K. Schmidt for gifting 5 memberships, which K. Schmidt also did on the earlier stream of today. Thank you to myself for gifting 5 free memberships. And you who were gifted, you now have access to all my members-only content, to your own emojis, and access to my Discord. I don't have anything to add, but I will have a teeny tiny scotch. And say thank you. Thank you for being here. Thank you for allowing me to do this. Hit the thumbs up, subscribe if you haven't. I just released a video on the Delphi case. And earlier today, I released a rant regarding body language expert Dr. G, who I believe is a fraud. But so there is content for you to watch. Tomorrow, I am going to go through bits of the Delphi case, specifically the interrogation. But that will be tomorrow. Oh, thank you, BrainSocks, for $2 over at Rumble. Thank you so much. You are so generous over there. Thank you so much. But I will see you all tomorrow for Delphi content. Monday for another verdict watch, starting at 9 a.m. Texas time. It will be, while we wait, it will be Judge Boyd, maybe some Judge Fleischer, maybe some Judge, what's his face again? Judge, I will have stuff for you to check out. But again, thank you so much for being here. And I will see you all back here tomorrow, Monday, Tuesday, for as long as I can. And I'm able to. But it's all thanks to you guys. Thank you again, and have a good one. And remember, hug your family. Unless your family's shit, then screw them and give your love to the people who deserve it. Bye-bye.